Lords, I beg to mention item number 15. And for the petitioner side, senior counsel says due to some health issue, it could not appear. And Lordship, this matter may be kindly fixed for a BC for hearing.
To be listed for hearing.
Yes. Then
Bail. Oh, 15. Yes, Your Lordship.
item number 15.
Okay. Miss D. Rillo. The Land Council submits that the Land Council, Senior Council, not senior, just senior. Our senior, Mr. Uttam Dekar, he is indisposed and pray for adjournment of the matter. When do you
1 week.
For-
After 1 week.
the prayer is allowed? This matter after a week. Okay.
BC.
Yes,
BC.
after a week.
Yeah, after a week, fix for a BC.
Fix for?
BC,
BC,
visual court.
you can take permission from registry.
Yes,
You don't have-
registry only.
Yes.
Yes.
Okay. So,
one long pending matter, SA number 1, 2023, this is the title dispute.
Title dispute.
Title dispute that has been appeal before this honorable court.
Mention before the senior.
Mentioned for 14, that there is fiction, matter there is 14.
No, title, what is this?
Title is pending before the law court.
Okay, you have filed before this court what?
Some respondent has filed. I'm the.
No, what is this petition about? Here,
Sale.
yes, sir. I think you have to mention before the senior bench. Yes. Okay,
And one more mention, item number 3, Katung.
yes.
That will be adjourned for today. I have told that the petitioner is out.
You are for a respondent. Have you informed the Land Council for the petitioner? Have you informed?
Yes.
Okay, Mr. T. Kappa, Land Council, appearing on behalf of the respondent, with the consent of the Land Council for the petitioner, prays for adjournment of the matter for the matter for 2 weeks. The prayer is allowed. This matter after 2 weeks. Okay.
My lord, if I may. My lord, I beg to mention item number 4. I am on behalf of the petitioner, my lord.
You are for the petitioner.
Yes, my lord. I've taken consent from the other side. This matter may be listed after 4 weeks, my lord.
Okay, Mr. G. Talo, with Land Council for the applicant with the consent of the other side, prays for listing this matter after
4 weeks, my lord.
4 weeks. The prayer is allowed. List this matter after 4 weeks.
Much obliged.
My Lordship, I beg to mention item number 1, Lordship, on behalf of J. Genie, Lordship. Conducting counsel J. Genie is out of the station due to some medical emergency, Lordship.
Okay, have you informed the other side?
Yes.
Lordship, I am for the respondent, Lordship. Lordship, this matter is pending since 2022, Lordship. So,
You have objection?
no, Lordship. Lordship, last chance may be granted, Lordship.
Mr.
Titarin,
Land Council submits that Mr. J. Genie, the conducting council, has some difficulties, personal difficulties.
yes, personal difficulties.
And prays for this matter
After 3 weeks, Your Lordship.
after 3 weeks. To which Mr.
K. Tabang, Lordship.
K. Tabang, Land Council for the respondent has no objection. The prayer is allowed. List this matter after 3 weeks. Okay.
Interim order may be continued, Lordship. Interim order may be continued.
Interim order is also there. That
Yes.
is why they are.
Yes.
objecting. Okay. The interim order passed earlier shall continue to the next date.
Yes. Obliged.
Yes, I'm well.
Yes.
I beg to mention item number 25 and 26, my lord. With a consent of other side, my lord, this may I pray, my lord, this be listed after 3 weeks, my lord.
It's criminal appeal.
My lord,
Why?
Lord,
You are for the petitioner.
I'm for petitioner. I cannot prepare, my lord. Okay. Earlier, it was deal by N. Ratan, my lord.
Mr. L. Parma, Land Council for the appellant. Submits that he is not prepared today, hence pray for adjournment of the matter for
3 week, my lord.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Further, my lord, I beg to mention item number 28, my lord.
This is 25 and
26, my
26.
lord. Now
Okay.
I am mentioning
28
28,
also.
28, my lord. Here
This
also,
is criminal appeal.
my lord, here also I have instruction appear in this case, my lord. 28, my lord. I will appear 28, my lord.
You, in 28, you are for?
I am for, I will appear as a for appellant, my lord.
Appellant.
My lord. Earlier it was dealt by N. Ratan, my lord.
Okay. Similar order, huh? 28 also, similar order, not prepared. Adjourned for 3 weeks.
3 week, my lord.
Okay,
Further, my lord, on item number 27, my lord, I am mentioning on behalf of learned senior counsel M. Pertin, my lord. He has instructed me to maintain the agent today, my lord.
Let it be on 19, my lord.
19. Okay, on the prayer made by the learned counsel for the petitioner, not and not objected to by the learned counsel for the respondent. List this matter on
19.
19 November.
Yes.
Okay, 19 November. Okay,
Available.
May I please, my lord?
yes.
My lord, with consent from the other side, my lord, I beg to mention item number 29, my lord. I am for the appellant, my lord.
Appellant.
Yes,
Mr.
M. Doji, my lord.
M. Doji, learned counsel for the appellant with the consent of the other side. Praise for listing this matter after
After 3 weeks, my lord.
3 weeks. The prayer is allowed. List this matter after 3 weeks.
Oblige.
Yeah, please, Lordship. Lordship, I beg to mention item number 10.
Item 10.
Yes, Lordship. On behalf of Mr. O. Modi, conducting counsel for the respondent. Lordship, this matter will be listed after 2 weeks. I have taken consent from the other side, Lordship.
You are Mr.
N. Novang.
appearing on behalf of Mr. O. Modi,
Yes,
learned
Lordship.
counsel for the respondent number
1 and 2, Lordship.
1 and 2,
Yes.
with the consent of the learned counsel for the petitioner. Praise for listing this matter after
2 weeks, Lordship.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Deeply obliged.
Should I like to mention item number 8 and 9?
8 and
8 and 9.
9. From petition. You are for
I'll put petitioner.
petitioner. The private respondents are also there.
Yes,
Have you informed?
yes, I have. The conducting counsel other side, then APP, let's be, she is not doing well.
Okay. You are Mr.
Arko.
R. Koi, learned counsel for the petitioner with the consent of the other side. Praise for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List the matter after 3 weeks. Okay.
So there is increment.
There is interim. So, para. The interim order passed earlier shall continue till the next stage. Okay.
Yeah, please, my lord.
Yes.
My lord, I beg to mention item number 7.
7.
Yes. And I'm for the respondent here. Maybe taken up after 2 weeks, my lord.
After 2 weeks.
Yes. This is the
There is
leading
interim
counsel.
also.
Interim is until further.
Hmm? Till further order. Yes. You have no. No. You are Mr.
S. Chetri, my lord.
Learned counsel for the petitioner. Why you want?
My lord, the leading counsel is out of session.
Okay. Mr.
S. Chetri, my lord.
Sir,
Sumit Chetri.
Learned counsel submits that the leading counsel, Mr. T. Tara.
K. Tama.
Okay.
Respondent.
Oh, you are for respondent?
Yes, my lord. I'm for the
Okay. Mr. K. Tama, learned counsel for the respondent, is out of station and hence pray for a gentleman of the matter for
2 weeks, my lord.
2 weeks, to which the learned counsel for the petitioner has no objection. The prayer will have list this matter after 2 weeks. Okay. Okay. Interim,
Interim lordship, until further.
it's still further order only. Okay, yes, okay.
May it please your lordship. Your lordship, item number 22. This matter was, your lordship, actually fixed for the consideration of interim prayer by the petitioner. And here in this case, your lordship, my learned brother G. Tado was appearing, your lordship. So on this, let this matter be fixed on Monday, your lordship. If on Monday, if he is not coming, we will appear in this case, your lordship, because we are not well acquainted with this case because he was dealing with this matter. So let this matter be listed on Monday, your lordship.
Okay. Case prayed for by Mr. Vete, appearing on behalf of
G. Tado, your lordship.
G.
G. Tado.
G. Tara, Lana PP. List this matter on Monday.
Yes, your lordship.
Okay.
Deeply obliged.
Lordship, in this case, the private respondent is yet to file affidavit. Matter of adjourned. Respondent number 2. Court is directed to file affidavit from the site of the respondent number 2. Indicate.
Mr. T. Tapatani, counsel for the petitioner is present. The respondent number 2.
Yes.
The respondent number 2 is yet to file affidavit.
Affidavit. Affidavit is after.
It's a squashing squarely based on the settlement. However, your lordship, they have made one of the party as a respondent, your lordship, not as a petitioner. So notice is issued to the respondent. Accordingly, they appear and they show time for filing of the affidavit to bring it into the record that they have entered into an agreement settlement. So it's yet to be filed, your lordship.
Affidavit in opposition or
No, your affidavit in opposition, but in the favor of the petitioner.
in favor of the.
Yes.
Okay.
Yes, we have made an agreement already.
Okay, is yet to file affidavit. In view of the above, list this matter after,
After we.
okay.
Obliged.
Your Honor,
Yes,
as in earlier this money has been paid 30%, and 50 was remained. So like he's seeking for some more time.
you have not yet deposited 50% of the decretal amount,
30 was deposited.
30 deposited, 20%,
15 is remained.
15. It was 50, if 30 deposited, 20 remain.
But that is past.
Miss Dirilu, Land Council for the appellant submits that although the appellant has deposited 30% of the decreased amount, however, the 20% is yet to be deposited, hence play for some more time. The prayer is allowed. List this matter after
2 weeks.
2 years. Is prayed for, comma, list this matter after 2 weeks.
Yeah, please, my lord.
Yes.
My lord, this is an appeal against the order passed by the learned civil judge senior division SEPA in title suit number 01 of 2023, wherein the learned trial judge only and relying on the documents filed in the written statement rejected of the
Lordship, this is a matter regarding application of Order 7, Order 7, Rule 11 for dismissing the plaint. And it's clear by the judgment by Honorable Supreme Court that while considering Order 7, Rule 11 for dismissing a plaint, written statement cannot be considered because the documents in the written statement has to be determined whether it is authentic or not by documentation or in the evidence. So it cannot be considered while considering dismissal of a plaint under Order 7 Rule 11. Here, here in this instant case, the learned trial court with
Civil judge, senior division.
yes civil
has
SEPA.
considering the taking in considering the documents in the written statement has dismissed the plaint. So this is a case where it can be reverted back. I have no objection because there is a clear.
Yes.
You are for the petition.
I'm for the appellant.
Appellant.
Yes, ma'am. The impugn order is
So where is the impugn order?
page 113. Page 113 of the appeal.
One one three.
Yes, ma'am. 113. Here, the learned trial judge has relied on the documents of in WS, whereas the only the amendments of the plaint
So
has to be-
where is the relevant portion where the learned trial court has taken into consideration of the written statement?
Well, the second paragraph, page 113, second paragraph. The defendant files their written statement wherein they have enclosed a deed of agreement and stated that the disputed land is a common land of all the members of Sangchoju of Lada Sarkar. Therefore, the plaintiffs cannot claim the right title ownership of the disputed land unless all the bona fide members of so and so are authorized. After hearing both the counsels, one of the preliminary issue framed to address the maintainability of the case is whether the case is maintainable or not. So that's here, my lord, the learned trial court has clearly relied on the documents and the written statement filed by the
So,
respondents.
who filed title suit?
I have filed the title.
You have filed title
Yes,
suit.
applicant.
And then the respondent filed written statement
Written statement. Basing on the written statement,
without
plaint-
hearing.
yeah, my plaint was rejected.
No, basing on the written statement without hearing.
No, Lordship, while considering a dismissal of a plaint under Order 7 Rule 11,
So the separate application must have filed under 7.
that can be done, but Lordship, first is.
That was not done. No separate application was
No,
filed.
it's not necessary. It's up to the court if just
Okay,
mere
initiative.
prayer is submission is enough.
Okay.
But here the point is whether during consideration of Order 7 Rule 11 dismissal, whether only the mere plaint and the documents annexed in the plaint were considered or not. Because while dismissing under Order 7 Rule 11, you have to only consider the plaint and the documents of
Yes.
the plane.
Hmm.
Because when you rely on a written statement,
Then it should be after trial only.
yes, because the documents in the written statement should be determined by authenticity during the course of documentation.
Well-
And but in the instant case, the learned civil judge,
Where is the provision? That is-
Supreme Court judgment. I think there is a Supreme Court judgment where
Yes.
it,
I have a judgment, that is 2021 9
Yes.
SCC, paragraph 25.
Correct?
25, madam. Page 112.
Yes.
Yes, para 24. On a perusal of the above authorities, the guiding principles of deciding an application on the Order 7 Rule 11 can be summarized as follows. To reject a claim on the ground that the suit is barred by any law, only the amendments in the plain will have to be referred to. And the defense made by the defendant in the suit must not be considered while deciding the merits of the application. To determine the suit is barred by res judicata, it is necessary that the previous suit is decided, the issue in the subsequent suit were directly and substantially in issue in the former suit. The suit was between the same parties or parties through whom the claim litigation under the same title. These issues were adjudicated and finally decided by the competent court to try the subsequent suit. Since an adjudication of plea of res judicata requires a consideration of pleading, issues, and decision in the previous suit, such plea will be beyond the scope of Order 7, Rule 11D, where only the statements in the plain will be perished.
This is appeal,
Yes, madam, appeal, because the rejection of the plain,
not the revision.
not a revision, because rejection of the plain, it becomes a degree as per Order 2 CPC. Order. Mentioned in my appeal petition.
Hmm?
It's the rejected, if the paragraph 6 of my appeal, page 14,
Yes,
why 14?
what is that?
It is, since the entire suit is dismissed and rejected by the learned trial court below, it amounts to degree in the view of provision of section 2 of CPC. Therefore, we have filed an appeal.
Yes.
Yes.
Page 42,
14, 1-4,
40,
1-4,
14.
yes, paragraph 6. Paragraph
Para
6.
6.
Yes.
Let us see the impugn order. Just this was in the initial stage,
Yes, it is.
immediately after filing written
Yes.
statement.
Yes,
Okay. So was there any prayer from the defendant side for dismissal? No.
here, Lordship, the only issue is the consideration of written statement. Otherwise, the court has right to
After filing of written statement, normally it has to be fixed for issues.
For issues and documentation.
Yes, but then,
Now here and after the filing of the during filing of written statement, we normally the preliminary objection is also filed for
yeah,
dismissal of them.
that was not filed.
It's there, but the objection or the order 7 rule 11 should only consider the plaint itself, not the documents in the
Right.
written statement. In the instant case, the documents of the written statement, an agreement which was in the annex in the written statement
Hmm.
was considered. On basis of that agreement, the learned
Okay.
civil judge has dismissed the plaint.
So which paragraph, in which paragraph we'll find? After hearing counsel, preliminary objection and. It says that written statement, the document has been considered.
It's from
That is the point.
second paragraph.
Documents of written statement cannot be considered. Well,
No, where it says
the
in
order.
the impugn order that it has been considered.
Second paragraph, my lord.
Oh, second paragraph.
Yes,
Itself.
yes, because from the,
Okay, the brief fact. It's a brief fact only.
yes, then there is a subsequent paragraph. I mean, that the defendants filed their written.
Okay,
statement,
okay.
wherein they have enclosed their deed of agreement dated so and so.
Where it says that it has been considered.
Common order, it is stated that the dispute is, therefore the plaintiff cannot claim rights ownership.
Where it says that it has considered the documents or the written statement for the purpose of disposal.
Lordship, this 114, the second para.
Second paragraph.
It is also found from the records that the plaintiff owner named C. Kamumiji sworn affidavit of the title suit is one of the signatory of agreement dated 8/5/2007. And this is the same agreement which was annexed in the written statement. And on the basis of this, it was dismissed.
Let us see the provision order 7
Seven,
rule 11.
Rule 11.
There also, has it mentioned
Mentioned regarding
regarding that. The written
whether
state-
the
written
written
state
statement should
cannot
be
be-
considered or not.
Hmm. Is it mentioned in the provision also?
No.
Not in the
It is
provision.
mentioned in the
Okay.
Supreme Court judgment.
Okay.
And
Mr. Your
draft
Mr.
S Chetty, my lord. S Chetty,
H.
S Chetty, Sumit Chetty.
Okay, Judge, Planning Council for the appellant. I've also heard Mr. Jackson. Planning Council appearing on behalf of, how many respondents are there?
20. 21.
21.
You are representing all the,
No, Lordship, I'm only representing for 1, 2, 3, 4, 5, 6, 7, 14, and 16. The rest, they have issued service and they have also published in newspaper also, but they
okay,
Ex parte
okay.
proceeding.
1, 2, 3, 4, 5, 6,
5, 6, 7, 14, and 16.
7, 14, and 16. So no one appears on behalf of the rest of the respondent, despite of,
My lord, on the last occasion, the ex parte proceeding has been initiated against
okay,
that person, as per
Okay.
order dated 28/8/2024.
okay.
28 August 2024.
Rest of the respondent, huh? Despite of service of notice upon them, this case proceed. He is proceeding ex parte against the rest of the respondents, huh? Now, as the rest of the respondent did not appear despite of service of notice, the case proceeded ex parte against them. Okay. Para. This is an appeal under section 96, read with order 41 of the Civil Procedure Code 1908. For setting aside and quashing the impugned order stroke decree dated 15/9/2023, whereby the Learned Civil Judge Senior Division SEPA has dismissed the title suit number 01/2023 by holding that the suit is not maintainable on account of estoppel by relying on the written statement and the annexure, more particularly it's agreement only which they
Yes,
have
agreement dated
okay,
8/5/2007.
particularly the agreement dated 8/5/2007 of the defendant. There. So you filed title suit.
Yes, my lord. Find the title suit.
The case of the petition, sorry, appellant is that. How many of you are there?
17, my lord.
And case of the
17.
appellant is that. They have jointly, sorry, that the appellant uh, it's appellants. 17 in numbers,
Yes,
jointly own and possess private land measuring 1 crore 3 lakh square meters. Measuring an area of 10.30 kilometer. This is square meter, square kilometer,
square meters, my lord.
square meter,
10.30, it's kilometer.
kilometer, square, not square kilometer.
Must be square kilometer.
Uh,
Because it's 1 crore square meters.
Okay. Okay, 1 crore 3 lakh square meter within bracket area 10.30 kilometer bracket close. At Lada Circle bounded by Lada Circle bounded by in the north Sachung village stroke Pachuk River in the south Kolong, Wake and Granjing village in the east Kolong Lada headquarter stroke Waki Nala and in the west Sachung village Wali Nala hereinafter referred to as suit land bracket close, that is within bracket stop. So what led you to file this suit?
That that there is a highway construction in the land,
Hmm.
particularly our land,
Hmm.
which comes under the, which goes through our land.
Hmm.
A department had issued a notification for compensation.
Hmm.
Thereafter, the hearing took place. Till the date of hearing, this respondent staff, they were completely silent. Thereafter, on 8/11/2021, when the disbursement of compensation regarding objections and this was published, in the next date immediately they have started raising objections, saying that few of the plaintiffs, they were the signatory to this agreement, and this disputed this common land, our plaintiff's land, was declared as common tribe land. So compensation should be given to all the tribes.
The respondent, when it was, the respondent disputed,
Is 9/11/2021. They filed an objection. It's in paragraph 2. 8 line from the bottom.
okay. So in the said lane, the government proposed to construct high altitude hill road.
Yes.
Okay, para, in the said lane, the government of India proposed to construct a high altitude hill road from Lada to Desai. And accordingly, the land acquisition notification were issued to the Department of Land Management, Government of Arunachal Pradesh, as well as by the Deputy Commissioner SEPA. When the compensation was about to determine, is it so?
Yes, ma'am.
The respondent lodged about to determine or for disperse.
But the disbursement of compensation, during the process of survey and
Okay,
public hearing.
then during the process of survey and public hearing, for disbursement of compensation, on 8/11/2020, compensation, the respondent for the first time, have raised objection by filing a representation dated 9/11/2021 before the DLRSO SEPA disputing the root lane. Start. After exhausting all available means of remedy, the appellant have filed a title suit number 01/2023 before the Learned Court of Civil Judge, Senior Division, SEPA. Praying for decree of right, title, ownership, interest, and possession over the suit land. Start. Where the respondent the respondent contested the case and filed by filing written statement. So at that stage,
Yes,
okay, by filing written statement, by annexing by filing written statement. And also raised preliminary objection to the maintainability of the title suit, a TS number 01/2023, on the ground inter alia that on dated, this would be in the slanting, on dated 08/05/2007, the plaintiffs along with the defendants have executed a deed of agreement before executive magistrate, SEPA, East Kamen District, Arunachal Pradesh, declaring their ancestral land as common land. Stop. Since the land in question were made common by executing a deed of agreement between the plaintiffs and the defendants, the suit is not maintainable. Okay. Stop. Fair. Upon filing written statement and on and hearing on the preliminary issues, by an order dated 15 by an impugn order dated 15/9/2023, the Learned Civil Judge Senior Division has rejected the suit on the ground of lack of cause of action. Stop. While rejecting the suit, the Learned Civil Judge Senior Division has also taken into consideration the written statement filed by the respondent and the document annexed thereto, more particularly the agreement dated 8/5/2007. Stop. It is submitted that while rejecting the suit, the Lanet Civil Judge Senior Division has heavily relied upon the state annexure, that is the agreement dated 8/5/2007, stating that the plaintiffs were also some of the plaintiffs were also the signatory of the state agreement dated 8/5/2007. And the plaintiff have suppressed the material fact before the court. Then suppress the material, said material on in the while filing the suit. Start. The Land Council for the para petition submits that while considering while rejecting the suit under while considering the case under Order 7, Rule 11D, the written statement and annexure thereto cannot be taken into consideration. So, however, in the instant case, the Lanet Civil Justice Division has heavily relied upon the written statement filed by the defendant and the annexure, more particularly the agreement dated. What was the agreement dated?
8/5/2007.
Okay, 8/5/2007. Stop. In support of this submission, the Land Council for the appellant relied upon the decision in case Sri Hari Hanumandas Totala versus Hemant Vittal Kamat and others, reported in 2021 9 SCC 99. The relevant paragraph at 25 is reproduced here and below. This 25, paragraph 25, 1, 2, 3, 4. Okay. It is at page 112. 12. For the region stated above, and in view of the decision of the Honorable Supreme Court in Sri Hanuman Das Totala versus Hemant Vittal Kamat, within bracket Supra, bracket close. The Land Council for a petition raised for setting aside and quashing the impugned order dated. What was the order?
till 9/20/20.
Hmm. 15/9/2023. Stop. Para. Mr. Gyatso, Atlantic Council appearing on behalf of the respondents. Respondent, those responding mentioned. Fairly submits that while considering the application, no application was filed. While considering the case under order 7 rule 11D. Okay. For rejection of the claim.
Para 70 is floor 11.
Hmm?
Para 70 is floor 11. Para 70.
17,
Yes, 107.
17 of your,
No, no, of the judgment.
hmm?
Judgment.
Judgment,
Para 70.
Supreme Court judgment.
Yeah.
Judgment.
Page 107.
Gyatso submits, fairly submits that. Order 7, Rule 11D, CPC provides that the claim shall be rejected where the suit appears from the statement in the claim to be barred by any law. However, in order to decide whether the suit is barred by any law, it is the statement in the plaint only which are to be considered. And the court, while deciding such an application, shall is not open to decide the issue. The court is not open to decide the issue on the basis of any other material, including the written statement in the case, much less the annexure. Thereto. And however, in the instant case, the Lawrence Civil Judge Senior Division has considered while considering for rejection of the suit has not only considered the written statement but heavily relied upon, had relied upon the annexure, that is the agreement dated 8/5/2007, which is barred by the law. Okay. Hence, the land council for the respondent, while considering the submission made by the land council for the applicant, has praised for remanding the matter before the trial court for
Proper adjudication of the.
proper adjudication of the
Restore the title suit and.
for proper adjudication of the suit. Stop. Para. Upon hearing the parties and on consideration of the submission made by both the land council for the parties and also as agreed upon by the land council for the parties, land council for both the parties. And while setting aside and enforcing the impugn order dated 15/9/2023, the matter is remanded back to the land trial court for proper adjudication of the case as per the provisions of law. Okay. Anything else? No, that's all. With the above observation, this appeal stands disposed of. Okay. What? To be corrected.
May I please close?
Be corrected that is also in the chamber.
May I please close?
Yes, item 12,
Item number, yes, 11 and 12.
11 and 12.
Yes, same analogous method. Lordship, in this case, the main conducting council, Sri A.C. Sharma, senior counsel is at Guwahati. Today, due to health reasons, he could not appear. So I pray that some time may be given for hearing of this case. Maybe after 2 weeks, 3 weeks.
Okay, Mr. D. Jabbar, Land Council. Submits that the conducting council, Mr.
A.C. Sharma,
A.C. Sharma,
senior counsel.
Land Senior Counsel for the petitioner could not appear
Yes,
today and pray for
3 weeks.
adjournment of the matter for 3 days. They are not objected to by the Land Council for the respondent, Mr. Pritam Thakur. Accordingly, the prayer is allowed to list this matter after 3 weeks. 11 and 12.
Lordship, in the meantime, there is an interim order dated 29/4/2024. It may be
Sir.
kindly copied.
The interim order passed earlier shall continue till the next date. Okay.
Deep law. Same analogous method, item number.
11 and 12.
Yes, I'm for the respondent.
Yes.
Same order may be passed. Deep law.
Similar order, huh? 11 and 12. Okay. Yes,
May I sign, my lord?
yes.
This is my lord, statutory pass appeal, my lord, against the judgment and sentence dated 23/9/2024, my lord. The conviction, my lord, was drawn under section 3 63 IPC, my lord. One is 363 IPC and 341, my lord. 363, my lord.
363.
My lord.
Punishment for
Kidnapping, my lord.
how many?
The punishment
period
imposed is, my lord, 3 years, 6 months, my lord.
Okay.
Yeah. This is, my lord, this being a past statutory appeal, my lord. My humble summary, let notice be go, my lord, in appeal, my lord.
Hmm?
This being a statutory appeal, my lord, let notice be go to go and, my lord, TCR, my lord, may be called for, my lord.
Oh,
In appeal, my lord. IA, my lord, I have a interim period, my lord. IA, my lord, yes, my lord, in term of, my lord,
just a minute, sir. This has been listed for the first time.
first time, my lord. In IA, my lord, yes, my lord, in term of order dated 1/10/2024, my lord, I am in on bail, my lord. My humble submission, my lord, till returnable date, my lord, that I may be allowed to remain under bail granted by the London trial court, my lord.
You are still on bail.
Bail, my lord, I am on.
Just a minute.
Yeah.
Three years and 6 months.
6 months, my lord. Though it is 3 and 6 months, my lord, these two open, my lord, penal open, all are bailable, my lord. That's why, my lord, under 389(3), my lord, trial court can grant bail, my lord.
No, the convict accused person are taken into custody.
My lord.
He has already been taken into
No,
custody.
my lord, that's why, my lord, I have
No,
anything,
order is
I
second.
my lord, subsequently, my lord, I invoked a provision of 389(3), my lord. Accordingly, I was released on bail, my lord.
Okay,
In
after taking him into custody, he was released again.
agent, my lord, on bail, my lord. That I have anything, IA, my lord, at page number 13, my lord, 1/10/2023.
No, just a minute. For how long he was inside the custody?
My lord,
During the trial, during the investigation and trial period?
in big extent, 2 months, my lord, 2 months,
2 months.
a month, my lord. Thereafter, he was on bail, my lord. During the whole trial, my lord, the accused was on bail, my lord.
This is POCSO.
Welcome, my lord. The section was succeeded, my lord, but during the whole trial, that was conviction was drawn only on 363 IPC, my lord, 34 IPC, my lord, or the 341, my lord. Alias case was registered under section 18 of POCSO, also, my lord.
So now he has been sentenced only under
363, my lord,
363 only.
my lord.
So registered section was under POCSO, which
Section,
8.
yes, sir. 376, 354B, 376, 307, 511, read with 818 of POCSO. But convicted under 363.
So he has been acquitted under all the other offense.
My lord, my lord.
Mr. Please permit. Help Lana Council for the appealing. Sir, Garrett. This is an appeal filed under section 374 within bracket 2 bracket close CRPC 1973. within bracket 4 under section 415 within bracket 2 bracket close of the BNSS 2023 bracket close against the judgment and sentence dated 23/9/2024 passed by the learned special judge POCSO stroke Pasigat in Pasigat SC within bracket POCSO case number 09/2028 under section 363, 354 within bracket B bracket close stroke 376, 307, 511 IPC read with section 8 stroke 18 of POCSO Act. Arising out of which PS?
Bowling PS, my lord, sorry, bowling PS.
Bowling PS case number 4/2018. Wherein the learned court by which the learned court has convicted and sentenced. No, you are challenging the convict. You are not challenging the sentence.
Challenging the conviction, your lordship. Why is it?
Conviction,
My
Yes, your lordship.
not the sentence.
Sentence also, my lord.
Hmm?
Sentence also, my lord.
Judgment and
Judgment and
sentence.
sentence, my lord.
Both.
Both, my lord.
Judgment and sentence dated 23/9/2024. Lordship will file in the court side.
Page number 19 is my prayer part, my lord.
Okay.
Judgment and
Whereby
sentence.
who is the appellant himself?
Himself, my lord.
The appellant has been convicted and sentenced. Where is the operative portion of the judgment? Sentence for. Okay.
Operative person, my lord, will find at page number 68, my lord. 68, my lord.
68.
Convicted and sentenced. For 3 years and 6 months for offense under section 363 IPC. Two accused.
Two accused, my lord. And next
The
item,
appeal is for both.
one, my lord. Next
Only
item
one.
is for second one, my lord.
Item number 14 is for the other co-accused.
Other accused.
Okay. And fine of rupees 10,000. And also 341 also.
Pardon, my lord.
For
341.
5,500 for offense under section 341
My lord.
and a fine and a fine of rupees 500 for offense under section 341
yes.
IPC with default clause. Start. The appeal is admitted. Issue notice returnable by 4 weeks.
Notice respondent number two. Respondent is there, your lordship, they've implemented.
Respondent number 2 is the informant.
Informant, my lord, complaint.
Okay. Since Mr. T. Learned additional IP. PP. Accepted notice on behalf of the state respondent. No formal notice needed to the said respondent. So the petition, the appellant shall take steps. Sorry. Steps upon the respondent number 2 by a registered post with AD within a week from today. Yeah.
My lord, may I
No,
pre-
in the after admit, huh? Admitted, call for the trial court record. Okay, then thereafter issue notice, huh? Okay.
My lord, may I
Yes, ma'am.
credit a notice to the respondent, my lord, I may be allowed to take to the concerned OCPS, my lord.
Okay. The
Usual court service is there on through OCPS.
No, your lordship, the usual course of service is through OCPS only, your lordship.
normally
then
in the
okay,
criminal is like that only.
Either both register post and usual post.
Okay, register post as well as by usual process.
Yes, your lordship.
Okay.
This is the main,
this matter of
main
appeal.
appeal.
IA, my lord,
IA.
I has intemperance. Case number 13, my lord.
Next, number 1.
Is
1-3, my lord. Annex number 1, my lord. This is bail order, my lord, by the trial court, my lord. Now, in terms of this order, my lord, I have already executed the bail, my lord. Now I am on bail, my lord. My humble submission, my lord, till returnable date, my lord, I may be allowed to remain on the bail executed in terms of this bail order, my lord. Next date, my lord, when the respondent appear, my
granted for 45 days.
no, my lord, my prayer was for 45 days, my lord, but my prayer, my lord, for filing appeal, enabling me to appeal was 45 days, my lord. My lord, next page number 14, my lord, if any time.
Just a minute, Let us see the in this order, page 13.
13, my lord.
Wait, huh?
In,
Both were granted bail.
My lord.
your lordship will find in clause 2, your lordship, both the accused shall be present in appeal before the appellate court within a period of 45 days and obtain appropriate order from the appellate court and submit the report to this court.
Where
In
when you are reading?
Page number 14, your lordship.
Page 14.
Yes, your lordship. This condition has been given in the second condition.
Within a period of 45 days.
Yes.
So what is your submission?
Lordship, here the conviction is for the fixed term.
Hmm.
Only in case of life imprisonment, your lordship, the test that whether there is a possibility of succeeding the appeal is there or not, that has to be looked into. In case of imprisonment for life, I have a judgment, Your Lordship, for that. And if it is for fixed term, then it's the discretion of this honorable court. This court can grant bail liberally if there is, unless there is an exceptional ground emerged from the record to decline it, Your Lordship. This is the recent judgment of the Honorable Supreme Court on that context, Your Lordship. In this offense, Your Lordship, this court can exercise its discretion, Your Lordship, without following that principle, Your Lordship. Your Lordship will find in this is a Bhupatji Sartajji Jabraji Thakur, Your Lordship, versus State of Gujarat.
Yes.
This is passed in 5/7/2024. Your Lordship will find in para 7, Your Lordship.
Yes.
There is a fine distinction between a sentence imposed by the trial court for a fixed term and sentence life imprisonment. If a sentence is for a fixed term, ordinarily the appellate court may exercise its discretion to suspend the operation of the same liberally, unless there are any exceptional circumstances emerging from the record to decline. However, when it is a case of life imprisonment, the only legal test which the court should apply is to ascertain whether there is anything palpable or apparent on the face of the record on the basis of which the court can come to the conclusion that the conviction is not sustainable in law and that the convict has a very fair chance of succeeding in his appeal. For applying such test, it is not permissible for the court to undertake the exercise of reappreciation of the evidence, the emphasis on the word palpable and expression apparent on the face of the record. So now, Your Lordship, so far as this present appeal is concerned, conviction is for the fixed term, wherein this principle or the test is not required to be followed. It's the court discretion, unless from the record it emerged that the bail has to be declined. But so far as, Your Lordship, I have seen the order of the trial court, Your Lordship. The trial court has also granted bail, Your Lordship. So I will leave it to Your Lordship discretion, Your Lordship.
Now, since there is a private respondent also.
Yes, Your Lordship.
Notice appeal, then he can be protected.
Yes, Your Lordship. It's that I will leave it to Your Lordship discretion, Your Lordship.
In or Mr. Alpha, land counsel for the applicant. I also have Mr. Theatre, land addition for the state of IP. This is an application under section 389 within bracket 1 CRPC or section 430 the corresponding section within bracket section 430 within bracket 1 of BNSS 2023 bracket close for suspension stroke stay of judgment and sentence dated 23/09/2024 in Pasigat SC POCSO case number 09/2022 under section 363, 354 B, 376, 307, 511 IPC railway section 8/18 of POCSO Act passed by the Sessions Special Judge POCSO, Pasigat. ECM Pasigat. whereby the convict, he is Tatem Tasing, my lord, has been sentenced to undergo an imprisonment for 3 years and 6 months, my lord, for offense under section. Earlier one, where is the improvement? Under section
363, my lord.
363 IPC, my lord. Which fine are
500 under 341 IPC.
fine of rupees 500
500.
for offense under section
341 IPC.
341 IPC with default clause. So, issue notice returnable by 4 weeks, we said,
Yes, 4 weeks. my lord.
since Mr. Sam, yet Lanet additional PP appeared and accepted notice on behalf of the respondent number 1. No formal notice need be issued to the said respondent. However, the petitioner said the applicant shall take steps upon the respondent number 2 by a registered post with area as well as by an usual process within a week from today. Start. Para. Since the applicant convict has already been granted, is on bail granted by the Lanet Trial Court on 1/10/2024, comma. The this, need to extend this bail
Yes.
or it has to be suspended?
No, my lord. Your lordship, it may be extended, your lordship.
It can be extended
Yes,
only
Your Lordship.
without suspending.
Yes, yes, Your
For a
Lordship.
time being, okay. The bail of the appellant, bail of the appellant. Appellant granted by the trial court on 1/10/2025 shall be extended till the next date, till the returnable date on the same terms and conditions. Okay. Okay. This is my after 4 days.
Yes, sir. Obliged.
Same order, my lord. 40 same.
Same, your lordship, same order.
Oh, same.
Yeah, co-accused.
Okay, the name will be changed.
Name will be changed, yes.
Okay.
Next, Tanyong Sitang, my lord.
His name is
Tanyong Sitang, my lord.
Tanyong Sitang instead of Tatlem Tasing, huh?
My lord.
Yes.
Only Tanyong Sitang.
IA number will be different.
IA number.
IA number. will
And
be
appeal number as
different, huh? It is IA 32.
Yeah.
The earlier one is 31.
Yes. Criminal appeal number is 32 and IA is 92.
Is it okay? Okay. Okay.
Obliged.
I'll leave it. Yes,
Your Lordship, on the last occasion, the CD was called for Your Lordship.
who is for the petitioner? No one appears on behalf of the petitioner. Whether after obtaining this interim bail, the accused has appeared before the IO.
Your Lordship,
Is it cooperative?
I have not received the CD, Your Lordship.
Okay, not received.
Not received, Your Lordship.
So, which PS case?
This is Papumpare, Your Lordship. Itanagar.
Talking about it.
Yes. The problem here is, Your Lordship, as I have already also mentioned yesterday, Your Lordship, the PO is engaged in other election duty and therefore we are having difficulties in communicating.
Okay. No one appears on behalf of the petitioner on call. Miss Jeannie, Lana Edison PP. Also submits that he has not received the CD as called for. In view of the above, this matter after 2 weeks.
2 weeks. Your Lordship.
Okay. Issue remind. Did he need to issue reminder? No.
Reminder, Your Lordship.
Okay. Issue reminder for case diary. Okay. Scan copy of the case.
Yes, that is Your Lordship. The- Lordship,
Yes.
even in item numbers 17, Your Lordship, we have not received the CD,
Not
the issue
received.
being the same.
Okay. Are you, this is also AB, are you protected by,
Interim, yes, Your
Hmm.
Lordship.
My lord, after obtaining the protection order by the Honorable Court, I appeared before the concerned IO.
okay,
Again, when I appeared, the concerned IO said, my statement is not to be recorded. So, in this case, the IO is not interested to record my statement. But
your
prior-
statement also not recorded.
Yes. Order was passed on 28th. And next day, 29, I appeared before the concerned IO SAPA.
Okay, he is not interested to record your statement.
Yes, yes. So, since my statement is not required in this case, so I beg to withdraw this AB.
So you are not required, it means,
As I appeared before the IO. The
Okay.
IO said my statement is not.
Not
required in
required.
this- Yes,
okay, that means
So-
you are not required to be arrested.
yes. So I have taken a photo of that also. If required, I will submit with
You
affidavit.
want to withdraw.
Yes, and withdraw for the purpose almost served because they repeatedly serve a notice to appear before the police, else I will be arrested. Consecutively, 2 notices were issued. Accordingly, I approached before the Honorable Court for protection.
Now he is saying that you are
Yes,
not required. So you want to withdraw.
Yes, I don't have any objection if he withdraws the application.
Mr.
Titoro.
Torong, Land Council to the petitioner as an instruction to withdraw this application, this the bail application. and prays for allowing him to withdraw the same stuff. The prayer is allowed. This bail application stands dismissed on being withdrawn. So the interim order passed earlier stands vacated. Consequently, the interim order passed earlier, passed on 28/10/24 stands vacated. Stop.
Different.
Yes.
Also, I'm for the respondent side for Oriental Insurance Company. We have to file the counter affidavit for that, need some time.
No one appears on behalf of the appellant on call. Stop. Miss D. Rilum, Land Council appearing on behalf of the, you are for claimant.
No, respondent, where a respondent, I'm
No,
for the
respondent
respondent,
is-
Oriental Insurance Company,
So you are for insurance.
yes.
Okay. Appearing on behalf of the respondent insurance company. Praise for further, how much time?
2 weeks.
2 weeks time to file objection. The prayer is allowed. List this matter after 2 weeks. Okay.
Mother.
My lordship,
Yes,
lordship, I may be allowed to 2 weeks time for filing of rejoinder, lordship,
filing.
for rejoinder. Affidavit, lordship.
Okay.
They have
You are
filed affidavit in
Mr.
opposition. Elbam,
L. Bum, Land Council for the petitioner, prays for 2 weeks time. Earlier also you made a prayer.
yes, yes.
Okay.
As a last opportunity,
Pray for
lordship.
further 2 weeks time to file rejoinder to the affidavit filed by the respondent. The prayer is allowed. List this matter after 2 weeks. Last chance. You are Mr.
I'm, yes, for respondent number 1.
Mr. S. Chera, Land Council. You are for
Respondent 1.
respondent. Okay. Land Council for the respondent is also present. It's okay.
Lordship, there is interim, lordship. Interim order is there. That may be
The
continued.
interim order passed earlier said continue till the next date.
Oh.
Yes.
Your Honor, service report gives the respondent number 2 is still awaited.
You are for
I'm for the petitioner, appellant.
appellant.
Yes, Your Honor.
What is your submission?
Service report is still awaited.
Oh, service report still awaited.
Yes, Your Honor.
Land Council for the appellant is present. Service upon the respondent number 2 is still awaited in view of the above. List this matter after 2 weeks.
Your Honor, can it be fixed on 27th of November?
No, service report is still awaited. What is, no point fixing it. Okay.
Well, lordship. TCR was called, lordship, and it has been received by this district.
Yes,
TCR was
Trial court record.
trial court record. was
not
called.
received.
Yeah, received.
Received.
Lordship, it may be disposed of on today, lordship. It is a joint application filed by the accused and the victim, lordship, for the causing of husband and wife, lordship. Purely matrimonial relationship, family dispute, lordship. Section is 498A, 323, 506 IPC, lordship. Only 498A IPC is non-compliant.
This is a joint petition.
Joint petition. And lordship, they have a one baby child, lordship, over 9 months. For the betterment of child, lordship, they had agreed to the settlement. Lordship. Now they are living as peacefully as a husband and wife.
Because the case is still pending.
Yeah.
Settlement is lordship. Annexure 4, page 51.
Informant is the father of the accused,
Okay. Informant is the father of the.
father of the accused.
Father of the accused.
Father of the accused.
Accused.
Yes.
Yes, that was. Then he exceeded. That means his own father.
Honorable Lordship, kindly see FIR Lordship, Annexure 1, page 22.
I think you've seen it earlier. Yes. Yes, FIR was lost by your father.
Father Lordship.
That becomes very difficult.
For using Lordship unparliamentary language Lordship, kindly see Lordship, Mary,
Just a minute. Page. Page.
page 22 Lordship, that is the FIR. Annexure 1,
Yes.
dated 27 September 2022 Lordship. To the officer in charge, police station,
Okay,
Arlo,
okay, come to the body of the.
This is relevant one is Lordship. Port line Lordship.
Night of so and so.
Sri Karmaloi, after arrival from somewhere else, started quarreling with his wife and beaten her in room after bolting the door from inside. When I and my wife insist for opening of the door, he refused, which the victim, my daughter-in-law, crying helplessly. My wife kicked the door and pushed open, and when we entered the door, he also physically assaulted me and heavily punched at my right jaw, which is still painful. He used very foul language to his murderers. They again threatened us to all physically eliminate, and before the arrival of the police, he ran away from the house.
Okay, the parties are then here in this case. You have met party to
One
the
is
father and
the-
mother also.
No. One is the
Mother
accused.
is also.
No. Petitioner 1 is the accused, 2 is victim, 3 is the informant.
Mother is also a victim. To his mother. Threaten all of them.
Yes.
Okay. So what is your submission?
Your Lordship, since they have settled the matter, and in this kind of case, Your Lordship, I think he deserve one last chance, Your Lordship, because
The case has been submitted into charge sheet.
no, yes, Your Lordship, and it's pending for CC,
CC.
and subsequent, the
Okay.
same was stayed by this honorable court, Your Lordship.
Okay.
It stayed. Now it's pending for CC, Your Lordship. Otherwise, Your Lordship, no, if they have settled the matter, then there is a remote and bleak chance of conviction.
Yes, yes.
And
Since
it
they-
fall under the.
Then have become
yes,
party, one
yes.
party.
And it.
Nothing will come.
Yes, it's squarely covered by the Lakshmi Narayan case, Your Lordship, when the matter is.
Lakshmi Narayan, do you
Yes,
have the?
Your Lordship.
Yes.
The family dispute, when the parties has settled the dispute entirely among themselves, then court can exercise its inherent power, Your Lordship.
Para
Mr.
15.1, L
Hard-
bump,
I'll take the. Facts of the case, no?
Yes, Your Lordship. The operating part is there in para 15,
It's same.
same, para
Para
15.
15.
Yes, Your Lordship.
Just a minute.
15.1 Lordship.
So all the same.
Yes.
Fifteen one,
15.1 Lordship.
15.1.
1. Yes, that's it.
Your Lordship, One, it said that the power conferred under section 482 of the code to quash the criminal proceeding for the non-compoundable offense under section 320 of the code can be exercised having overwhelmingly and predominantly the civil character, particularly those arising out of commercial transaction or arising out of a matrimonial relationship or family dispute, and when the party has resolved the entire dispute among themselves. This squarely covers it.
Mr. You are Mr.
L1, Lordship.
21 item.
L-bomb. What the L stand for?
Libby.
Hmm?
Libby.
Maybe. Ida bomb, not the Ida
No,
coach.
there is two council.
Lordships. Council for the petition. I've also heard Mr. P80, Learned additional PP for the state of AP stuff. Para. This is an application under section 482 of the Code of Criminal Procedure, 1973. For compounding of the non-compoundable offense charged against a petitioner. No, just a minute. Joint petition.
Against the petitioner number 1. Lordship.
Okay, the petitioner number 1 is the accused,
Yes, 1 is the accused,
and 2 is the wife,
2 is wife, 3 is the informant.
3 is the
Informant, father. Lordship.
okay, then leave that one. This is a joint petition filed by no, this is a joint petition filed under section, okay, 482 of the Code of Criminal Procedure 1973 for compounding the non-compoundable offense. Charge against the petitioner number 1 and for quashing and setting aside of the FIR registered dated 27/9/2022 and charge sheet number 54/2023. And also trial proceeding being GR case number 115/22. Within bracket state versus state of AP versus Karmar Loi bracket close under section 498 dash capital A stroke 323 stroke 506 IPC arising out of ALO PS case number 55 stroke 2022 pending before the Court of Chief Judicial Magistrate ALO staff of para 2. The petitioner number 1 is the accused in above GR case number 115/2022 in bracket semicolon. The petitioner number 2 is the wife and victim And petitioner number 3 is the informant in the above GR case number 115/2022. Stop. Para. The brief fact of the case is that on 27/9/2022, the petitioner number 3 lodged a written FI against petitioner number 1 before the IO of the before the OCPS ALA. For physically assault against the petition number 2 and the petition number 3 himself. Start. Based on the above written FI outcome, the police has registered the case being ROPS case number 55/2022 under section 498A/323/506 IPC. He was arrested
Yes.
and petitioner number 1 was arrested in connection with the said PS case. Para. After completion of the investigation, the IO of the case has submitted laid charge sheet into the case against petitioner number 1 for offense. Petitioner number 1 under section 498A/323/506 IPC. Whether you have also annexed the order passed by the learned Chief Judicial Magistrate.
Yes, Lordship. Page 50, Lordship. Page 50. This is order dated
50.
50. Order dated 17/6/2024, whereby CC has been fixed on 6/8/2024, Lordship.
And the case is pending for consideration of charge before the court of the Chief Judicial Magistrate. Stop. Para. It is the case of the petitioner that during the pendency of the case, the parties have amicably settled the matter by executing a deed of agreement among the parties, whereby the okay, so first party and second party have love affairs which culminated. Okay, just a minute. The land council for a petition on summary statute. The petitioner number 1 is the husband, and the petitioner number 2, victim, is the wife of the petitioner number 1, and the petitioner number 3 is the father of the accused petitioner number 1. Stop. It is the further submission of the land council for a petition of further submission that during the pendency of the case, and since the parties are husband and wife, and since the victim is the wife and the informant is his own father, the parties has entered into, the party has amicably settled the matter by and executed a deed of agreement on 15/7/2024. Stop. As per the deed of agreement dated 15/7/2024, the parties have mutually reconciled and settled the misunderstanding arising out of the FIR. What is the condition? Only that.
For the interest of the family and more particularly for the 9 months old baby loss.
So there is no any where it says that the parties has no more further grievances and then want to withdraw the case, etc. Where is that?
Next page, Lordship, page 52.
Yes, case number
Loss
10,
for
so
loss.
which is trial?
Original Lordship. Married Lordship.
Okay, okay. So in the it was not visible. Actually.
Yes.
And in the interest of the family, more particularly for the 9-month-old baby, the parties, the informant and the informant and the victim has agreed to withdraw the case. Case pending before the case against the petitioner number 1 pending before the Learned Court of Chief Judicial Magistrate Alam. It is further submitted that since the victim and the informant has no further grievances against the victim petitioner number 1 and informant petitioner number 2 has no further grievances against the accused petitioner number 1. They have agreed to withdraw the case from the case pending before the Chief Judicial Magistrate. The case pending against the petitioner number 1 before the Chief Judicial Magistrate Court, Alo. Stop. However, since the offense involved in the case is non-compoundable, especially the which one is non-compoundable?
498 capital L.
498A is a non-compoundable offense. So have you prayed before the Chief Judicial Magistrate?
No, Lord.
No. The petitioners have filed by these petition under section, this application under section 482 of the Code of Criminal Procedure, the CRPC. Start. There are other cases also. Rest are detailed in there. Okay. So that is the, I think, the fact of the case. The rest are detailed inside.
Obliged, Your Lordship. 5.1 or 15.1.
15.1.
15.1.
15.1. Property violence. 15.1.
Okay.
All right.
Obliged, Your Lordship.
Yes. Dispose of, huh?
May please, Your Lordship.
Yes.
My lord, here the matter pertains to a proceeding of a tender process, which is completely in violation of the direction of this honorable court, as well as the undertaking that was given by the secretary before this honorable court, my lord. May I just place the facts, my lord? Yeah. 23 is the writ petition, my lord. And there is one more, that is the contempt. For the violation, we have filed this contempt application.
Okay.
The matter of
Contempt was filed earlier.
my lord. Sorry.
The contempt petition was filed.
My lord, both
Earlier
were
to-
filed along with together. My lord. They were
Together,
filed together.
okay.
This matter ought to have come up for motion. There is an urgency because tomorrow the financial bid is going to be open. If I may apprise your lordship. the facts,
Yes.
my lord. My lord, the matter relates to its village vibrant program under the PMGSY.
Item 23.
Item 23.
Okay, relates to
Relates to village vibrant program under the PMGSY. my lord. Under the scheme. Pradhan
Village?
Mantri Village Vibrant Program.
Okay.
It's a construction of road
Yeah.
under the Pradhan Mantri Gramya Sadak Yojana.
Hmm.
My lord, if your lordship kindly find, the Secretary to the Government of India, while implementing the project, has wrote a letter on 19/10/2023, all the deputy commissioners of the districts of the Arunachal Pradesh. my lord. Page 35, your lordship will kindly find. First, I'll just show one paragraph from that order. page 35. This is a letter by the Secretary of the Government of Secretary RWD to all the Deputy Commissioners, my lord. Page 35, last paragraph, your lordship will kindly find. Page 35, bottom, last paragraph. The paragraph starts from, the process for land donation drive require an organizing a transit walk by the administration, associating the departmental engineers together with the Panchayat Pradhan, local revenue, land record officers, staffs, forest officials. On completion of the event, a proceeding of the meeting shall be drawn and duly signed by the stakeholders. Open and transparent communication between the community and the local authorities build trust. Therefore, for ensuring successful drive, it is essential that all stakeholders are well informed about the project objectives, benefit, and potential impacts on livelihoods. With page 36. With long-term perspective, all the bridges on these roads with a span of so-and-so meters are being designated to accommodate a carriage of so-and-so meters. That they are built to handle the load of so-and-so as records are expected. But what I wanted to show from this paragraph is that the secretary, for implementation of the project, asked the deputy commissioner to organize the transit walk. And what this transit walk is, my lord, where the road will be constructed, all the people has to be made to be participated, so that they know that whether their lands are being affected or not. Because there are two procedures: either you acquire the land for the purpose of construction, or voluntary donation by the landowners. Now, pursuant to that, for the project, a approval was given by the Government of India, that is page 37. Here, your lordship will just note the date of the approval, my lord. 9 January 2024. My lord, kindly take note of this date, my lord. Now, surprisingly, before the approval is being given for the implementation of the project, page 39, my lord, file, the additional deputy commissioner issues land availability certificate. That lands are available, and your lordship will find in the bottom portion, the land belongs to community land and is free from all encumbrances. I'll show, my lord, this land availability certificate, ex facie, is issued on the basis of assumption, my lord, and which the ADC on a RTI reply, he has admitted that. Now, my lord, we'll find page 46 are the MOU, which claims to be the basis of this land availability certificate. Page 46, my lord. Here, my lord, will just note the first line, that the first party is the land with transferable right, landowner with the transferable right. So, this MOU were executed by certain persons concerning their private lands. However, your lordship has find in page 37. Sorry.
It was when this was?
My lord?
This
MOU was executed on 12th February 2024. These were subsequent
MOU between
MOU between the state and the Gao Panchayat, the village headman, I think.
State also?
State also.
No.
State is the second party. My lord, to find page 46. Yes. Governor of state through so-and-so designation, PIU, RWD, signed as of hereinafter referred to as the.
Okay, state and
yes,
landowner.
Well, there are certain illegalities which has been committed by the authorities while implementing the project, and therefore a forum which was constituted who are aggrieved by such illegalities, my lord, approach this honorable court. Your lordship will find that page.
What about this? This MOU, according to you, is
my lord, it is been executed by a person concerning his private land, and the availability certificate which your lordship have seen.
It was given earlier.
It was given earlier.
So after that, the landowner started coming up. You are agreed by this?
No, we are agreed by the manner how the authorities have proceeded to implement the project, my lord. The PMCSY has laid down a guideline.
You are?
I am one of the my lord, resident where the project is sought to be implemented.
Okay, you are for?
My lord.
You are for?
I'm
The private?
I'm a private person.
Okay.
They are trying to implement the project over the private lands of us. And therefore, there was a writ petition filed before this honorable court where there was a categorical direction where, if your lordship will find, my lord, the order passed by this honorable court will clear everything, my lord. First, the first order, there were 3 orders passed by this honorable court concerning these issues, my lord. The
No,
first order, my lord, will find.
This order, you said earlier is shown in one, non-income certificate.
Land availability certificate.
Sorry, land availability
Availability
certificate issued by the ADC of the
Issued
concerned
by the
district.
ADC of that concerned district,
Concerned district.
saying
But
that
thereafter only this, it appears that the first party, second party.
somebody has executed some MOU. But at the time,
It's not you.
it's not me. It's not me. And the time when the ADC has issued the availability certificate to get the project approval, there was no MOU executed. He, on the basis of an
No
assumption-
landowner.
Huh?
At that time, there was no.
There was no landowner who has executed yet.
Yes.
Thereafter, as these were the anomalies which were being found by the authorities while implementing the project, the manner, page 86, your lordship will find, is the order passed by this honorable.
No. By showing this page 46, what do you want to show?
Well, by showing page 46, I wanted to show that at the time when the availability certificate was issued by the ADC, there was no MOU.
Okay.
There
But
was
this
no
is,
MOU.
this is subsequent.
Subsequent, they have entered into an MOU with some landowner. But at the time when the land availability certificate was issued,
There was no
for,
landowner.
for taking the approval,
Yes.
Hmm. there were no such land
Landowner.
available as a community land for the purpose of implementing of this project, implementation of it.
Hmm.
Am I?
There was no.
There were no lands
Hmm.
which were donated by any person for implementation of this project. At that point of time, there was no availability certificate. Subsequently, there were some MOU with some private individual who has executed the MOU in respect of their private lands. But the land availability certificate, if your lordship has seen, it says that the community lands are available.
Yes. In the
There's
month
no community lands available.
2023 June.
No, 2023, there was no community.
Hmm.
Now, my lord will kindly
There are
find
no community land.
there were no community land which were donated for the purpose of implementation of this project.
But then the
Authority subsequently has entered into an MOU with some persons concerning their private lands.
No. So this, by this. 5/6.
Yes. 5/6/2023.
Hmm.
Here it is shown that lands are available,
It's a
community lands are.
community land.
Malab?
It's a community land.
He shows,
Hmm.
he expresses that there are lands, community lands available for the purpose of implementation of the project.
Hmm.
Now, this project is governed by a guideline that is issued by the government of India.
Just a minute. There are more than one letter.
There are more than one letter. These are 3
Land
villages.
certificate.
These are
Okay.
3 villages of that district
Yes.
where the project is sought to be implemented.
Okay, so subsequently.
Some MOUs were
signed.
executed by
MOU was signed on 5/2.
on 12th February 2024.
Okay, so. Okay, so by this this MOU, some owner started coming up.
No, it is this MOU were shown to be executed by the Gauburas of the village. But what the Gauburas has the purpose of the MOU is their own private lands, not the community lands.
Separate or within the same land where the certificate already given?
Yes,
that-
same lands.
Not a separate land?
No, not separate.
Okay, this is subsequent, okay, yes, then,
Now, my lord will kindly find page 49 is the guidelines which governs this entire scheme, my lord, the scheme PMGSY, page 49.
Yeah.
The relevant clause, my lord will find at page 61, 6.12 first. Page 61. They are bound to follow this guideline for the purpose of this project, my lord. As it is a central government project, the state is bound to follow this guidelines, my lord. My lord, page 61,
yes,
clause 6.12. May I just read?
yes,
It will be the responsibility of the state government district panchayat to ensure that the lands are available for taking up the proposed road project. A certificate that the land is available must accompany the proposal for each road work. It must be noted that the PMGSY does not provide funds for land acquisition. This does not, however, mean that the acquisition cannot be done by the state government at its own cost. The state government may also lay down guidelines for voluntary donation, exchange, or other mechanism to ensure availability of land. The process of making land available for the road work should subserve the common good and also be just and equitable. The details of the land available should be reflected in the local land record to avoid disputes. It may be noted that the works are sometimes held up because at the time of preparation of the DPR, actual availability of the land was not investigated, or because the local panchayat was not taken into confidence about the proposed alignment, and disputes subsequently arose. As a part of the PMGSY process, all states shall include a simple, my lord, kindly note this, a simple non-formal transit walk to be organized by the assistant engineer at the time of preparation of the DPR. The Panchayat Pradhan, local Patwari, the JE, the women PRI members and the representative of the women self-group would participate in the transit walk. Forest officials would also be included where the forest land is likely to be involved.
what is this transit walk?
Transit walk is basically it's a measure to identify, suppose, my lord, the land, there is a proposal for construction of the land so and so meter. This land will pass through which road? Whether this, by way of this transit work, it is identified that whose lands would be involved in construction of that road. This transit work makes the people also aware that, okay, this road will touch my land. So there is an option for the landowners, either their land has to be acquired, or they may voluntarily come up for donating the land because it's otherwise a developmental project.
Okay.
So my lord will now kindly find page 64, one more clause, 8.4. Well, these are the preconditions for before preparing the DPR. Page 64,
Yes,
clause 8.4, my lord. While commencing with the preparation of the DPR, my lord finds page 64, clause 8.4.
8.4.
While commencing with the preparation of the DPR, the PIU will hold a consultation with the local community through mechanism of the Gram Panchayat in order to determine the most suitable alignment, sort out the issues of land availability, including forest land, moderate any adverse social and environmental impact, and elicit necessary community participation in the program. For this purpose, the PIU will organize the transit work as follows. The transit work shall be organized by the assistant engineer in accordance with clause para 6.13, 6.13, which I read, my lord, just now. During the work, the issues relating to the alternative alignment, land requirement for the road, and its impact on the landowner, etc., will be discussed with the members of the local community present. Environmental impact on vegetation, soil, and water, etc., shall be identified for resolution. During the work, due opportunities shall be given to the interested person to put forward their point of view. At the end of the work, the alignment shall be finalized after recording the issues that arose during the work and the action taken proposed to resolve the issue. This shall be reduced in writing signed by the Pradhan Secretary. A copy of this minutes along with the digital photograph of the transit work must be attached to the finalized DPR. So it's a mandatory condition. The PIU 8.5. PIU will ensure that the following in preparing the detailed project, the rural roads constructed under the PMGSY must meet the technical specification and geometric design standards given in the Rural Road Manual of the IRC, and where the required Hill Road Manual, the choice of the designs and surface of the road could be determined. So what I intended to show, Miller, from clause 8.4, that before the preparation of the DPR for this project, the precondition is that the transit work has to be done, and the photographs of the transit work and the records of the transit work has to be attached with the DPR. Well, it's a very beautiful scheme, Miller, so that the people comes to know before the project is sought to be implemented. So that while undertaking the project, there should not be any issues regarding objection, because it's a developmental project. And therefore, the government has ensured that before the project is implemented, you take everyone's view. Now, these things were not done. And therefore, my lord, a forum which was constituted, being aggrieved by the violation of the guidelines by the RWT, Miller, approached this honorable court at page 86. Miller. The first writ petition that was filed by a forum constituted for the purpose,
Page 85.
page 86. The names continues till page 98. My lord will find the order from page 98.
Yes.
May I skip the hard part, and my lord will kindly come to directly to page 99, third paragraph,
Yes.
the subject matter of the that writ petition.
Mm.
The grievances raised in the present proceeding by the petitioner is that the respondent authorities have issued land ability certificates for construction of road in question, which also includes areas governing the lands of the petitioners, and it is contended that the same lands of the petitioners have not yet been acquired by the authorities, nor they have voluntarily donated the land for the purpose of construction of the road in the question. The PMGSY scheme mandates that it is the responsibility of the state government, district panchayat, to ensure that the lands are available for taking up the proposed road under the scheme. A certificate that the land is so available must accompany the proposal for each road work. The state scheme also stipulates that under the scheme, no fund is provided for land acquisition, and as such, acquisition shall have to be made either by the acquisition by the state concerned at its own cost or procured from the landowners by way of voluntary donation. The petitioner have also relied upon a communication of so-and-so, wherein it has been stipulated that the land ability certificates were issued in anticipation of the agreement for donation of the land by the villagers. In view of the said proposition, the clear stipulation as contained in the scheme, it is hereby provided that the respondent shall issue, before issuing the NIT, my lord will kindly note this, shall before issuing the NIT for construction of the road in question shall ensure that the lands requisite for the purpose is either acquired by the state government or procured from the landowner so affected by way of donation. It is clarified that this court has not restrained the respondent authorities from proceeding to construct the road in question, but has only required the authorities to undertake such construction strictly in accordance with the provisions of the PMGSY scheme, and after that, the land so required is either acquired by the state government or procured by way of donation from the landowners so affected. Well, at that point of time, there were no NIT issue, and therefore, this honorable court, by way of this order, directed them that you go ahead, you proceed with the implementation of the project, but you follow the PMGSY, because this will involve, and this ensures that an opportunity is given to all parties whose lands will be affected by way of by the implementation of the project. Therefore, thereafter, my lord, the chief engineer, page 101, took note of all these grievances, and he was conscious enough And therefore, by page 101, he has directed all the superintending engineer, the executive engineers of different divisions to withhold tendering process. My lord finds page 101. This letter was issued by the chief engineer, RWD, who is the authority who for the purpose of implementing this project. He issues to all his subordinates saying that withhold all tendering process. If you have gone ahead with any tendering process, withhold all tendering process till the process of acquisition, etc. is finalized. My lord finds the last line.
Yes.
My lord. Thereafter, my lord, the petitioners along with two others, they approached the secretary, the chief engineer, the deputy commissioner, additional deputy commissioner, executive engineer, raising their grievances at page 102. A representation, by way of this representation, they raised their grievances that the transit of the PMGSY guidelines has not been followed in their villages as well. Then thereafter, my lord, a RTI application was made. At page 107 is the reply by the same ADC who issued the land availability certificate. My lord would be surprised to see this, my lord. He accepts this. Page 107. Yes, 8 numbers of land availability certificate was issued from my office during my sitting as ADC Sayantazo on the request of the Executive Engineer Rural Department in anticipation of agreement by the landowners. The certificate was issued in good faith and for the development of the villagers. There was no malafide intention from my side in issuing the land availability certificate, nor was any ill motive. No any correspondence. My lord finds this. He admits that there is no transit work. No any correspondence for organizing a transit work with the stakeholders was received from the higher authorities during the issue of the certificate. And as such, I have not violated the government instruction guideline during the day of the issue of any certificate. No any SOP related to construction of PMG was received during the day of issue. Hence, no ill motive justifies it. But here, be that as it may, my lord, he accepts that this land availability certificates were issued in anticipation of the understanding with the donors. And at the time when the project approval was given, there was no land. And he also admits that before the DPR was prepared, no transit work was organized. So, admittedly, my lord, they have violated the PMGSY guidelines. Thereafter, my lord, page 108, these petitioners, along with two others, approached this honorable court, my lord. I'll skip, my lord, the till paragraph 8 is the grievances which were raised before this honorable court in that petition. Page 110, it starts. My lord will come to page 114.
Yes.
Well, though the land availability certificate, the issuance of land availability certificate, the violation of the PMGSY, those were a subject matter of challenge in that petition. But however, this honorable court, my lord, will find page 114, para 9. May I just read from that?
Okay.
On being inquired, the petitioner could not clarify as to whether the respondents in the RWD department in implementing the project and in their villages have issued any NIT or not. The respondent also could not clarify in that regard. After hearing the parties and considering the entire aspects of the matter, the court is of the opinion that instead of keeping this matter pending, it is disposed at the motion stage itself, directing the petitioner to submit a fresh representation before the so-and-so authorities, along with a certified copy of this order, stating that their grievances on or before 8/7/2024, obtaining necessary acknowledgement from them in that regard. In the event of filing such representation by the petitioner within the time so specified, the respondent will consider the same in accordance with law, clarifying further, my lord, kindly find that, clarifying further that in the event of implementing the road project by the respondent authorities in the village of the petitioner under the Vibrant Village Program, it shall follow the relevant guidelines and rules and procedure prescribed in that regard as applicable including the PMGSY guidelines as applicable for the VBPs, Village Vibrant Program. So, my lord, at that stage, as there was no NIT issued in respect of the petitioner's villages, and therefore, This honorable court thought that the secretary would look into the grievances and we were asked to file a representation. Accordingly, when a representation was filed within the stipulated time at page 116 million. And the secretary acknowledges it by receipt of 26/6/2024, meaning thereby, my lord, the representation were submitted in compliance to the court's order. Now, my lord, what happens? While our representations were pending, my lord, page 120, NIT is issued 5/7/2024. Page 120, my lord.
What is this?
NIT has been issued for 8 packages. We are not concerned with the other 8 packages, my lord, because the petitioners are apprehending their lands will be affected for 3 packages. And therefore, the subject matter of the writ petition is only 3 packages. Now, my lord, as our representations were pending and no authorities have not decided anything and they have proceeded with the tender process, we approach this honorable court again, my lord, page 121.
This is NIT issued in respect of
NIT issued in respect of 8 packages, my lord. 8 packages.
we are concerned with 3.
We
out
are
of this-
concerned with-
out of these 8.
Out of this 8.
Yes.
But before I come to page 121, my lord, I would like to humbly submit one thing. We are not opposing this developmental work, my lord. Our grievance is that while implementing this developmental work, you are bound to follow the PMJSY guideline and you have bypassed everything. There were direction from this honorable court twice that you need to follow the PMJSY guideline. And they have disobeyed this court's order thereafter and proceeded with the NIT without following the PMJSY guideline. And therefore, my lord, we approach this honorable court by page 121. The order starts from page 123. May I read from para 4? Malab, this will have a relevance in this case, malab, present case.
Yes.
Therefore, I would like to read this order entirely. May I read?
Yes.
Paragraph 4. The petitioner, by way of instituting the present writ petition, has raised a grievance with regard to the manner in which the respondent authorities are proceeding to execute the work relating to construction of road under the VPP scheme in the area wherein the land of the petitioners is situated. The petitioner, being aggrieved, had approached this court by way of instituting WPC number 235, assailing the manner in which this said VPP scheme was being implemented. The court, on consideration of the issues involved in the writ petition, proceeded to dispose the same by an order dated 17/6/2024, directing the petitioner to submit a fresh representation before the authorities mentioned in the order, along with a certified copy of the order, and the respondent authorities so mentioned were directed to consider the same in accordance with law. This court further clarified that in the event of implementing the road projects by the respondent authorities in the villages of the petitioners under this VVP scheme, the same shall be so implemented following the relevant guidelines and the rules and procedure prescribed in that regard as applicable, including the PMJSY as applicable for the VVP scheme. It is contended by the petitioner that in terms of the direction passed by this honorable court, the petitioners have submitted a representation on 25/6/2024. The same, however, is pending disposal. In spite of the direction passed by this court, it is contended by the petitioner that the respondent authority has proceeded to issue NIT for construction of road under the VVP scheme and for their maintenance. Being aggrieved, the petitioners have instituted the present proceeding. The learned counsel for the petitioner, by drawing the attention to the materials available on record, has contended that the guidelines as applicable for implementation of the said VPP requires the respondent authorities to ensure that the lands are available for taking a proposed road under the scheme, and the certificate that the land is so available must accompany the proposal for each work. It was further highlighted that the said scheme also stipulates that no fund is provided for land acquisition and the land is required to be arranged by the state government either by acquisition at its own cost or procured from the landowners by way of voluntary donation. By referring to the land availability certificates brought on record, issued by the authorities of district administration, it was contended that same were issued on 5/6/2023.
I think we have to continue at 2.
Mal. Very good.
Today, this is listed for.
Mal,
Actually, this should be come in motion column.
it ought to have been come up in motion because it is a matter where no notices issued. In the meantime, we file an additional affidavit.
Whether notice already issued earlier?
No, no notice issued.
Okay.
My lord may issue notice on.
But we have
Notice
an
can
interim
be
prayer. We have an interim prayer.
Interim would be.
Interim, my lord, because they are proceeding with the tender process now.
My lord,
They
they are
all
claiming,
financial.
they are,
But anyways, well,
my lord, they are claiming that by executing this road, their land is going to affect it. So they have nothing to do with this tender process.
because
why
the
to-
tender is issued for execution of this work.
While
Once the
executing,
work
if
order
their
is issued,
land is not affected, there is no issue.
Your land is affected.
well, how do we know? Because the transit work has never
Well,
been done.
Then
So how do
Atto.
we know that our
Then
lands are
Atto.
affected? Because the basic idea of the guideline is
No, once it is affected, if it is affected, then only you can come.
Well,
for
that-
the-
Yes,
but
then
no,
only you
open
can
to-
come.
well, the basic grievance. Now, your lordship will kindly give me 2 minutes at 2 o'clock. I'll show there was a direction from this court, and my learned friend appearing for the secretary gave an undertaking before this court that without redressing our grievance, they will not proceed with the tender process. That was an undertaking given before this court.
But despite of this court
And they have
direction
no-
to follow
Well,
follow the procedure.
I am not denying his.
Hmm.
There was order from this court to follow the process and
Yeah.
to submit representation. They have submitted representation. In the meantime, they have submitted another representation stating that they are withdrawing that representation. We have no more issue. This is
That's
the
not correct,
letter.
my lord.
This
Because
is the letter.
in additional affidavit, we
Now,
have brought
before,
on.
But then
before
unless,
deciding,
unless you know that your lane is going to be affected or your lane is affected, on what basis you should come before?
No, because that is why I wanted to show clause 6.2. It says that before the DPR, why this transit work was directed to be done, so that the people comes to know that through which road this is, because the land available certificate issued, but the MOU issued by executed by 3 persons. There, the entire road cannot be constructed upon their land.
Right, right.
My
But
lord,
what is
can I appreciate-
difficulty? What is the difficulty conducting this? What
Transit.
there is no difficulty, my lord. I'll come to.
Okay, we'll take it.
Oh, wait,
Sure.
two.
Which case?
My lord, in the repetition.
No,
WPC.
this order was passed in which case?
The earlier petition which was filed by the petitioner, my lord.
Same petitioner.
Same petition, along with 2 other petitioners. Here in
Regarding same matter.
same matter, same subject matter. What happened, my lord, if your lordship recalls, we filed an application, we filed a representation. Thereafter, we approached this honorable court. This honorable court in WPC 235, my lord Justice Pathak's order. In that repetition, as there was no NIT called at that point of time, this honorable court relegated the matter back to the authorities to decide to redress the grievances that is raised in the representation. Meanwhile, without disposing that representation, they have issued the NIT. Therefore, it again brought us to this honorable court, this WPC 272, page 121.
Okay.
My lord also recalls the page 101, the order, the letter of the chief engineer, which I have pointed out. The chief engineer also took note of this, and therefore chief engineer has withheld all tender process. Well,
But this was issued by them, then again.
the NIT was issued by the superintending engineer. He's a subordinate to the chief engineer.
Okay.
Well, a total go-by has been given by the superintending engineer to the chief engineer's letter first, to the direction passed by this honorable court, where the honorable court has said that we are not restraining you from proceeding, but you follow the guidelines. And this honorable court very rightly pointed out, clarified it that you follow the procedure because that will give an opportunity to the affected person to come up with their grievances. Now, I'm allowed to kindly find page 121, the order that was passed by this honorable court after the NIT has been issued.
After.
The
this
NIT was
this
issued.
issued in 5/7.
5/7. After the NIT was issued,
Okay,
we
then-
challenged that NIT on
Okay.
the ground, my lord, that our representations are pending. You have not redressed our grievances, and now you are proceeding with the tender.
Hmm.
Now, page 123, the order starts, my lord.
Yeah.
May I read? Para
Yes,
4,
ma'am.
para 4 onwards. The petitioner, by way of instituting the present retribution, has raised a grievance with regard to the manner in which the respondent authorities are proceeding to execute the works relating to the construction of road under the Vibrant Villages program scheme in the area wherein the land of the petitioners is situated. The petitioner, being aggrieved, had approached this court by way of instituting WPC 235, assailing the manner in which the Village Migrant program scheme was being implemented. This court, on consideration of the issues involved in the petition, proceeded to dispose the same by an order dated 17/6/2024. My lord, this is the order by my lord Justice Pathak.
This is
17/6/2024.
This order is.
17/6/2024. That your lordship read at page 108, whereby we have been given a liberty to file our representation before the secretary and the other authorities, directing the petitioner to submit a fresh representation before the authorities mentioned in the order, along with the certified copy of the order, and the respondent authorities so mentioned were directed to consider the same in accordance with law. This court further clarified, in the event of implementing the road project by the respondent authorities in the villages of the petitioner under the said scheme, the same shall be so implemented following the relevant guidelines and rules and procedure prescribed in this regard as applicable, including the PMGSY program guidelines as applicable for Vibrant Villages program schemes. It is contended by the petitioner that in terms of the direction passed by this court, the petitioner submitted a representation on 25/06/2024. The same, however, is pending disposal. In spite of the direction passed by this court, it is contended by the petitioner that the respondent authority has proceeded to issue NIT dated 5/7/2024 inviting bids for construction of roads under the Vibrant Villages program scheme and for their maintenance. Being aggrieved, the petitioner have instituted the present proceeding. The learned counsel for the petitioner, by drawing the attention to the materials available on record, has contended that the guidelines as applicable for implementation of the scheme requires respondent authority to ensure that the lands are available for taking up the proposed road works under the scheme, and the certificate that the land is so available must accompany the proposal for each road. It was further highlighted that the said scheme also stipulates that no fund is provided for acquisition of the land, and the land is required to be arranged by the state government either by acquisition at its own cost or procured from the land owners by way of voluntary donation. By referring to the land availability certificate brought on record, issued by the authorities of the district administration, it was contended that the same were issued on 5/6/2023, and it was certified therein that the land is available for construction of road in that area. It was further contended in the said certificate that the land as procured are community land and free from all encumbrances. The contention as made in the said availability certificate, however, disputed by the petitioners. The learned counsel for the petitioner further submitted the approval of the project proposal was granted under the Vibrant Villages program scheme for 2023-24 was granted by the central government on 9/1/2024. However, even before the said concurrence was given, the district administration of East Cumming district had issued the land availability certificate. The learned counsel for the petitioner has further drawn the attention of this court to a reply furnished to a legal notice issued by the petitioner, wherein the district administration of the East Cumming district had submitted that 8 land availability certificates were issued at the request of the executive engineer, Rural Works Department, Science Division, and the same was also issued in anticipation of the agreement by the landowner and also done in good faith. By highlighting the above position, the learned counsel for the petitioner has submitted the petitioner herein have not donated their lands voluntarily, or their lands were not acquired by the state respondent by way of initiating a process of acquisition in that matter. It is further highlighted by the learned counsel for the petitioner that the chief engineer, RWD Itanagar White Communication dated 28/3/2024 had required all his subordinates involved in the matter to withhold the tendering process till the land acquisition process for construction of roads under the Village Migrant program is finalized. It is the contention of the learned counsel for the petitioner that in spite of the said position, the respondent authorities have proceeded with the process of issuance of tender, and accordingly, in the event of the said process is concluded, the land of the petitioner is utilized for construction of road in question, their rights would be prejudicially affected. Now, I'm allowed to kindly take note of para 9 and 10, very important. Mr. So-and-so, learned standing counsel for RWD on instruction received has submitted that the secretary RWD Government of Arunachal Pradesh Itanagar, in view of the grievances expressed in the matter by various persons, had by communication dated 16/7/2024 required the chief engineer to hold the tendering process till the representation petition as filed in the matter by various persons raising grievance as regard the construction of the road under village vibrant villages program scheme is undertaken. So and so has submitted that the respondent authorities would now first consider the matter. Kindly take note of this because this is an undertaking. They has submitted that the respondent authorities would now first consider the grievances raised in the matter by various persons and thereafter only would proceed with the works pertaining to the construction of road under the said scheme. In view of the said position, this court is of the considered view that the authorities having undertaken to consider the grievances of the persons including the petitioners herein pertaining to the construction of road under the vibrant village program, a consideration on merit of the issues as arising in the present question is not called for in the present proceeding. The secretary to the so-and-so is directed to take on record the representation as submitted by the petitioner on 25/6/2024 and thereafter to consider the same on merits. At this stage, the learned counsel for the petitioner has submitted that the issue pertaining to the landability certificate as well as the fact that the land of the petitioner was not donated by them or acquired by the state government was not raised in the representation dated 25/6/2024 and accordingly praised that the petitioner may be permitted to file an additional representation in the matter, highlighting the state position for consideration by the secretary concerned. The prayer is accepted. Accordingly, the petitioners herein are permitted to bring on record the further representation in the matter by 29/7/2024. In the event such representation is filed by the petitioner, the secretary shall take into consideration the same along with the representation dated 25/6/2024 and thereafter on considering the grievances raised in the matter strictly in the lights of the guidelines pertaining to village migrant program scheme and of the connected scheme SOP etc. Proceed to dispose the same by issuance of a speaking order. The secretary, while proceeding to dispose the representation as submitted in the matter in terms of the direction herein above by the petitioner, shall also consider the validity of the landability certificate issued in the matter by the authorities of district administration. The secretary shall initiate the exercise as required of him in terms of the direction as passed herein above and conclude the same with the issuance of a speaking order within 15 days from the date of receipt of the fresh representation from the petitioner herein, along with the certified copy of this order. Now, my lord, based on this direction, we have submitted the additional representation, page 129, on 27/7/2024, which was received by the secretary, office of the secretary on 29/7/2024. Page 129.
And what happened to this representation?
Nothing. They did not dispose they have not disposed the representation, and thereafter, my lord, will be shocked to see page 133.
Yes.
Well, how the court's order are being disobeyed, my lord, by this superintending engineer, my lord. He disobeys his superior's order, chief engineer's order, which asks him to withhold the tender process. He disobeys the secretary's order. He disobeys this court's order, and on page 133, he issues a circular. 4th October, saying that on 15th October, the tendering committee will open the technical bid of this 3 packages. These are the 3 packages which we are concerned. Now, on 15 October.
15 October.
15 October. Yes, tender was open. Tender was open. And now they are proceeding to open the financial bid, my lord, tomorrow. Now, my lord, will kindly find page 134, my lord. 134.
Yes.
We immediately on 15/10, when the technical bid was about to open, my lord, we have served the representation upon the secretary again, saying that there is a court's order. The court's you made an undertaking before the court that you will not proceed with the tendering process unless the grievances of the petitioners are taken into consideration by way of passing a speaking order. So, but the technical evaluation bid is going to open, and this letter informing that this is purely a contempt, and this was, my lord, page 138. Your lordship will find the copy of this letter was also served upon the chief engineer, the superintending engineer, the executive engineer. Page 138, my lord, will find.
Yes.
But despite this, my lord, they have proceeded and they have opened the technical bid on 15 October, my lord. Now, my lord, challenging these actions, my lord, I am before your lordship, my lord. My lord, this superintending engineer, my lord, he is not above the rule of law.
Yes, yes.
Yes.
Why he is doing so? Despite a repeatedly court order, it's kind of a reminder that the court has repeatedly issued, and at the same time, you see, after issuance also, and then you have also undertaken, it appears. So why he is doing?
My lord. Writ petition 235. The present petitioner is along with two.
What is this?
My lord,
This is I am coming.
lordship will take my additional affidavit, not the loose paper which has been submitted now, my lord. Because we have brought on record this document. My lord, only-
Let me submit. Let me submit.
No, I am not completed. My lord, I like to clarify, my lord, this.
What? You have
The-
some additional?
Yes,
affidavit
one
also?
additional affidavit we have filed it, my lord,
When?
yesterday.
Just a minute. Okay. Just a minute. Take your seat.
This, my lord, additional affidavit to bring on record, or what happened, my lord, why we filed this additional affidavit? On 24/10, this matters were listed before this honorable court, my lord.
24/10.
24/10. Challenging this, after 15 tone, when they have opened the technical bid and they were proceeding to open the financial bid, my lord, we approached this honorable court. On 24/10, this matter was listed before this honorable court for motion. On that day, my learned friend apprised me that the reason for not disposing the representation is that this petitioner, along with the other two petitioners of the other writ petitions, they have filed an application before the authorities, withdrawing their representation and saying that we don't have any further grievances, and we don't want to pursue this matter. That letter, which my learned friend has handed over just now by hand, my lord will find that letter at page 143 of that additional letter. My lord finds what page 143? 143 of the additional letter.
Additional?
Additional letter.
Yes.
In compliance with the Honorable Guwahati High Court order dated 18/7/2024, my lord, this is Nayar's order.
Who is this, the person who wrote this?
No, they claim that it is the petitioner who has submitted before the authorities, and therefore the authorities have not disposed the representation.
But this is not the petition according to you.
My lord, we have immediately, therefore, on being submitted this copy, I took an instruction from my client. I say that whether you have given this representation or not, then they have categorically stated in their affidavit that we have never signed this representation, and page 145, they have lodged an FIR also against this.
Okay, so this, according to you, or according as per the FIR, that means this was forged.
This was forged.
This otherwise is the name of the petitioner.
Name of the petitioner. They have said that we have never submitted any such application. But just a preponderance of probability, my lord. A person who has approached this court, engaged lawyer, approached this court twice, why would they withdraw their representation? Because this honorable court relegated them to submit representation, and the authorities were supposed to consider their representation. Why the authorities, in what terms the representation is required to be considered? Whether the PMGSY guidelines were followed or not. Well, this clearly cast a doubt upon this superintending engineer who has bypassed all his superiors' order. He's so interested in proceeding with the tender process, this cast a doubt upon him. May I submit one thing more? Malad, this honorable court, the secretary by way of a communication prayed before this honorable court and made an undertaking that they will not proceed with the tender process until the grievances are redressed. But this was a clear undertaking, my lord, before this honorable court. And based on that undertaking, your lordship has found that this honorable court said that we are not deciding this issue on merits because as the authorities have undertaken to consider the issues themselves. Therefore, this honorable court did not decide this writ petition. And now this letter, your lordship will find, this letter are also without any dates.
Which letter?
My lord, the letter of withdrawal, which they are claiming page 144, my lord.
Okay.
This does not bear any dates. But this clearly indicates, my lord, in my respectful submission that the authorities who has disobeyed the order now has created this letter so that they take a justification that no, as it is it's a contempt, my lord. This 15, the circular that was issued on 410 is a clear contempt, my lord, of this honorable court.
I think you have received a copy of the additional affidavit
Yes.
also?
Yes.
You have received?
Yes.
Okay, it's there only.
Yes.
So, now, is it okay? Now you tell me why he is doing so?
My lord, I'll. The first writ petition filed by regarding this Vibrant Village project in case of Cheng Tajo division was writ petition 99, only 2024 by 53%, stating that they are the landowners. Their land is the project which the state is going to implement pass through without their consent, government has prepared a DPR. That was the allegation. Subsequently, they have withdrawn that.
No. So, leaving aside all those, the past one.
No, I'm coming to sequence, my lord.
Hmm.
I'm coming to then that writ petition was withdrawn by the petitioner on 2/5/2024. This was before election. After election, they withdraw. So your lord can make out the sense. Then after that, present petitioner along with two others, they approached this court by 235. Then subsequently sent cause of action, they filed another writ petition, 272. So both the writ petition was disposed of with direction that their representation to be considered. Then when they have submitted representation, in the meantime, again, they have submitted this representation. Here in this representation, 3 of them have signed. The remaining documents here in this writ petition, which the petitioner and 2 others have signed, this signature is same. But after this,
The withdrawal petition?
yes, withdrawal and all the relevant documents.
Hmm.
After this withdrawal, then the secretary, the further tender process was started. Till now, it's not final. This, as per their, even they have not put the date.
Just a minute. At the time of submission of this purported withdrawal of the representation, whether the writ petition was pending,
No, not pending. Writ petition was already disposed.
already disposed of.
With direction to file fresh representation. So they filed fresh representation. That is representation dated 25/6/2024.
So
Now,
by this letter, they are
By
saying
this
that the
letter,
fresh
they are-
representation they are withdrawing.
we have withdrawn. My lord, read the content.
Okay.
Content itself also, there does not reflect any that this land was ours. They said 3 beneficiaries who have donated land, they are also willing to donate the lands. For the interest of the public, they are withdrawing the representation, which means that there is no further issue regarding that land dispute, regarding execution of project through their land. So the further,
But then you see, subsequently they have lost FIR also.
that is,
And-
that after filing,
But
this-
when this was fixed? For
my lord,
just
this matter was.
just one clarification. When for opening of the financial bid was ordered,
Financial noted.
refixed.
That
Tomorrow they are opening the final.
So tomorrow, but when it was refixed, the date of fixing, when it was passed order,
this case was filed on 23/10/2024
2310, and then this
Yes.
was,
and move on 24/10. So when I brought this letter,
hmm,
then they had sought time to the court to get instruction from, but it was not recorded. Now, after so many days thought process, they have lodged a FIR against the authority. So I'm coming to the point. Now the issue is, there is FIR, we are welcome. Let there be investigation. Now, they have to disprove that the signature is not his signature. After that, now two petitioner left. Now only one petitioner is before this court. The present petitioner, this petitioner on 15th October, when the technical bid was supposed to open, notice was issued. He submitted representation. He alone. Two other petitioners were not in this page. This is page 134, Annexure 7. My lord may peruse the Annexure 7. Annexure 7 is representation is submitted by only the present petitioner.
Annexure 7 page,
Page 134. Then relevant portion is 138.
okay.
Now here he has put signature in different way. In all other previous representation, previous communication, his signature is tally with the withdrawal letter. Now here he has put a different signature in different way. So this shows that, and two more petitioner has been left out. Again, when I brought these documents, they might have discussed again, three come together and they have filed FIR against the. Now my submission is that without passing any order, my lord may observe that police to verify this, make a proper investigation, let there be a proper investigation, and let there be a forensic test about this signature.
No, but whatever may be, but then since when the court has directed to follow the procedure,
No,
why?
my lord, you have, my lord,
But
there
then
was
even if he doesn't file this representation also, you have to follow the procedure.
yes, the petitioner themselves said the procedure has been followed. They have said that in their withdrawal letter. Procedure was followed. They have themselves said, may I read, my lord? In inviting your kind attention,
Which one?
that is that the withdrawal letter which I furnished.
No, withdraw letter, he
Page
refused.
140.
Yes,
One. Withdrawal letter.
Page 140.
143 next year. Oh, it's not there.
The same letter which he is handing over.
Yeah, I'll read. To the secretary of the government such and such, withdrawal of representative dated such and such in terms of Honorable High Court order dated such and such, WPC is in inviting your kind attention to the subject cited above, we the undersigned have submitted the representation dated 25/6/2024 entailing our detailed grievances in terms of the common court order dated such and such by the Honorable High Court, Itanova Permanent, that due to certain misconception of facts, we have filed the writ petition being WPC 235 before the Honorable High Court, Itanova Permanent Bench, UPA 4, the reason that this road from Tagampu to Harayangpo, road from Tagampu to Lotayangpo, road from Sabah Bania road to Yakulibaya, there has immense socio-economic and international border ramification with China. After due consultation with various stakeholders, it has come to light that department has followed all the SOP of the PMGS guideline while preparation of detailed project report, transact work, and land acquisition was also done. And being beneficiary of these three roads are willing to donate land for free of cost for larger public interest of the nation, in particular Cheng Tajo, block East Caming district. Consequently, upon keeping in mind, we have decided not to pursue our representation dated such and such as submitted to you, entailing our grievances, which may be treated as withdrawn with immediate effect without any condition in larger public interest, and your good office is requested to proceed with the finalization of tender process as initiated in terms of e-procurement press notice issued by the executive engineer Cheng Tajo, the East Caming district, inviting item rate such as electronic tendering system for construction of road under BBB, Vibrant Village project, including maintenance for 5 years, such and such. The register in appropriate class in district of East Caming for 8 numbers of packages. We put onto our signature with sound health and mind, with free will for the larger interest of state, for more particular for East Caming district. So after this only
Just a minute.
process for technical bid was
After issuance of this NIT, where is the court order? Where was the court order directing to follow again?
18/7/2024 order, page 121. 121. Relevant paragraphs are page 126.
No,
Nine.
just a minute, sir. So this was, as per this, direction was to issue the speaking order.
Yes.
So even after withdrawal also, you were supposed to pass a speaking order.
Yes.
Thereafter only could it proceed.
no, Melo, once they withdraw, there's
No,
if their
the
representation
court directed to, the court
survive.
has directed to proceed with the dispose of the same by issuance of a speaking order. Supposing
Yes, if
thereafter the representation was filed.
if their
And
representation,
according to you, this subsequently the petitioner has withdrawn. And
if they have not withdrawn, we could have passed speaking.
no, even after submission or even after the withdrawal also,
Review file. Pardon.
Now that part I have to
it
take
was
this up.
duty on the part of the authority to pass a speaking order saying that represent submitted and subsequently withdrawn. That would have been the speaking order.
That I have no, that might be
So
wrong.
that at least could have done as per the order and direction of the.
That part I don't have instruction.
So in order to clarify yourself and to clarify the petitioner also, and in compliance of the court's order, that speaking order you ought to have passed before proceeding.
No, that may be there, but I have no instruction for that.
So that having not done is there is trouble, because now he is refusing, he is denying that he has filed this.
My lord,
representation.
that's good. Now here file a
This is-
FIR.
Now this has
FIR.
come into the
Let
question
there
of
be
fact.
investigation. I'm,
Question of, yes.
yeah, let there be investigation. If they has not really withdrawn, then the authority will face the consequences.
Okay, what we'll do is we'll issue notice.
Issue notice and let the
At this-
investigation.
At this stage, my lord,
Well,
let
that-
there be a statement. Yes, what my friend is proposing, let there be an investigation. I'm ready for it, my lord. I've filed an application, FIR
Well,
for the authority.
otherwise also their grievances is that
And
without following the procedure, their land is going to affected. That is their grievances.
So, but now.
Whether it's
see,
their
now
land or
see,
whose
now
land.
even after receipt of this withdrawal also, you are supposed to pass a speaking order saying that they have, as per the direction of the honorable court in so and so, they submitted representation. But while the representation is pending disposal, they have subsequently
No,
withdrawn.
that part I have to take.
So that I
instruction.
think you have.
in fact, my lord, they have never come up with a review application. When there is a direction,
Mhm.
there is a direction from this honorable court to consider the grievances.
Yes.
They could have very well come up before this honorable court with a review
Saying-
application,
saying that they-
saying that they have withdrawn it,
Right,
so we
right,
can't
right.
follow this direction.
Right.
Because this direction remains.
That could have.
No,
That
once they have
And
withdrawn.
my lord, very interesting part is, my learned friend is saying, showing page 144 to show that all the guidelines has been followed, the SOP has followed. Now, my lord,
No,
you'll be
I am not
surprised to
interested.
see, my lord, he is relying on my statement that SOP is followed. But his own officer in page 107, my lord, the ADC, he says that there was no transact work done. His own officer, he says that I have issued this land availability certificate
10?
without place 107, my lord.
Hmm.
The ADC who has issued the land availability certificate, that very person
My
in a
lord,
reply to a legal notice at
confusion, I
page
will clarify.
107.
My lord, I will clarify. The process is like that.
Yes, yes.
The first ADC has to issue whether if the road is constructed this place, whether there is land or not. That availability only have to given. Then after sanction, then there will be transact or whether someone's land is there or not. To identify that transact what is to has to
But
be
that procedure would be contrary to clause 6.12 of the guidelines. They have done it, they have created their own procedure then.
Otherwise,
Page 107, my lord, will kindly find
construction
one,
approval.
my lord, page 107. Just for a moment, my lord.
Okay.
107 is the ADC, my lord, who has issued the availability certificate, my lord. Serial number 2, my lord, he admits, no any correspondence for organizing transact work with the stakeholder was received from the higher authorities during the issue of the certificate. And as such, I have not violated the government instruction. He says that there was no direction given, therefore, no transact work was given. So he is not liable for any illegality. But be that as it may, he accepts that there was no transact work done. And there was an undertaking by the secretary before this honorable court that they will not proceed without disposing the representation. Para 9, my lord. It was an undertaking before the court that they will first consider the grievances of the petitioners.
Para 9 of?
Para 9 of page 126, my lord. But can these authorities play with the court like this, my lord?
No,
Page 126, my lord.
since they have withdrawn the
My lord,
Yes.
nothing grievances remains.
so and so has submitted that the respondent authorities would now first consider the grievances raised in the matter by various persons and thereafter only proceed with the works pertaining to the construction of road under the said scheme.
When they have withdrawn their grievances, what more is to
Be that as it may, my lord, we are disputing that we have never withdrawn it. That's now a matter of investigation.
Otherwise, also
Either
their
as it may, my
grievances
lord,
land issue.
there
If
is
their
a
land is affected, they
There
get-
is a direction from
there
this
is
honorable court. What
other remedies
prevented
also.
them from coming before this honorable court to review this order? They would have very well passed the speaking order that yes, you have issued the representative.
Otherwise, my lord, the petitioner have nothing to do with this tender process. If their land is affected, they have other remedies also. So there is no
Heard Mr.
ground for
Land
State.
counsel for the petition. I've also heard Mr. B. Thara, Land counsel appearing on behalf of the respondent. How many respondents are there? You are representing,
Yes.
There are 9
Nine.
respondents.
and then you,
I
Thara
am
to
for-
represent,
I am for 3, then 6,
okay, then
then
one,
8,
1, 2,
and
and
9.
you're for 3, 6,
6, 8 and 9.
8, and 9, and you're for?
4 and 5, my lord.
Okay, and Mr.?
Union
Union.
Marto Kato is there.
No, okay. Mr.
Wiry Ramnews.
Y. Ram. For respondent number 4 and 5.
Yes, sir.
Martho Kato is not there.
Not there.
Please serve him a copy, my lord. 1, 2, and 7.
Thank you. Your grievance, particular grievance in this writ petition is
My
against
particular
three,
grievance- Hello?
against three project.
Against three projects.
Where it is, where do we
My
find?
lord, your lordship will find my prayer portion at page 30, my lord.
Prayer number
Prayer number 2, my lord.
2. But in this prayer earlier also you met.
Yes, and this honorable court says that as the authorities have undertaken to take care of the grievances, therefore the court has not entered into the merits of the case, decided the merits of the case.
Yes, of L.
The 18-7 order, my lord, paragraph 10, page 126, my lord. Paragraph 10, in view of the said position, based on the undertaking that was given by the court, the court is of the considered view that the authorities have undertaken to consider the grievances of the persons, including the petitioner's hearing, pertaining to construction of road under the village vibrant program. A consideration on merit of the issues as arising in the present proceeding is not called for in the present proceeding. So my grievances which was raised, the challenge which was raised in the earlier two repetitions still remains unanswered. my lord.
So your grievance here is that despite of court's direction,
They have proceeded with the tender.
Where have you stated that?
My lord,
By filing this,
Sorry, the submission, sir.
writ petition under 226 of the Constitution of India, the petitioner contended that despite of the court's direction, where is the direction?
Page 121.
121.
21.
No, 21 is
But the operative portion, my lord, will find out
operative portion.
from page 127, paragraph 14. Paragraph 13.
Direction given by this court in WPC
272 of 2024.
WPC 272 stroke 2024. That that on the representation submitted by the, to be submitted by the petitioner, the secretary to the government of Arunachal Pradesh Rural Work Department shall take into consideration the same along with the representation dated 25/6/2024, and thereafter on consideration of the grievance is raised in the matter, strictly in the light of the guidelines pertaining to the Vibrant Village Program scheme and of the connected scheme, SOP, etc., proceed to dispose of the same by issuance of speaking order from the respondent authority has proceeded decided to proceed with the opening of
the financial bid.
financial
Technical bid, is it?
that was
technical
also
bid?
in
This is also-
violation of
Yes, violation of the court
Okay.
order.
When it was,
It was done on 15/10,
the proceeded with the opening of the technical bid on
on 15/10/2024.
15/2024, and then subsequently decided to open the
The financial bid
bid on
tomorrow.
tomorrow is on
8/11.
8/11/2024.
Lordship wanted to see my challenge with page 26, paragraph 30, mein. My specific challenge in the repetition. Page 26, paragraph 30.
32.
Paragraph 30, 30, page 26.
So circular issued already circular.
Yes, by this
For-
circular, they have
410.
fixed the date for opening of the technical
For
bid. of
fixing the
bid.
time and date for opening of the part one technical bid of the BBP. Okay, it is submitted, huh? That though the respondent number 3 is
The secretary.
okay during the proceeding of WPC number 272/2024 by way of its written communication dated 16/7/2024 required the chief engineer PMGSY within bracket RWD to hold the tender process till the representation filed in the matter by now it is not various person.
There are other representations also. Therefore,
Okay,
the secretary apprised this court.
By
But
various
many people
persons,
have come up with the
by
defense.
various persons raising grievances as regards the construction of roads under the VBP scheme is considered.
Different projects,
Different.
for different projects,
different
not for this particular.
Okay, different purpose.
Yes,
Construction of roads under the
BBP. under
VBP
Chiang-
scheme,
Chiang Tajor division.
scheme under Chiang Tajur division
Of
is
the
considered. Okay, is considered. Okay, stop.
Altogether 8 projects was.
Hmm?
Altogether 8 projects.
8 projects.
Okay. Construction of the road under the VBP schemes. VBPI, yeah, 8 project.
There was 8 projects.
Okay,
So other package they have withdraw or some they have.
okay.
Now this 3 project was.
Okay, the departmental council also submitted. The departmental council has also submitted that the respondent authorities would now consider. The head also has submitted to consider the grievances raised and thereafter would proceed with the work pertaining to the construction of road under the said scheme. But the respondent number 8 in most arbitrary and illegal manner has issued a circular dated 4/10/2024 for fixing the time and date for opening of part 1 technical bid of the VVP work in respect of LO 24. There's road from Tagampu GSY Road to Hara Yangfo, LO 25 is road from Tagampu to Loto Yangfo, and LO 23 Sawa des Venia Road via Yakli to Dia under the executive engineer Chayang Tajo on 15/10/2024. So we are not concerned with the other project,
No,
Not
we are not.
only with three. Okay.
Out of three, last one, L23 financial bid open yesterday. That already open. Other two, I have no idea.
So this is with regard to three not yet open.
No,
It's fixed
three,
on-
one
I
has
have no
not
idea
open.
because they have,
Out of
what
three-
they are doing is, even
out
if
of
they are
three-
opening the financial bid, they are not notifying in the website.
So
Out of
Nobody
three-
knows it, but
as per this notification, it has to be on 15th.
on 15, they have done it for technical bid. Now, financial bid, what my learned friend says,
On-
for one, they have done yesterday,
Hmm.
two, they are
Fifth.
doing it tomorrow.
One on fifth already open.
So where is the notification fixing for tomorrow? Where was that?
No, they have not notified him.
Okay.
These are the surreptitious manner.
No,
how they
there
are
will
doing.
be in the report, there will be, that will be given.
Okay, we'll just issue notice. Returnable by
3 weeks.
3 weeks. Okay. Since Mr. Tarak G. Tarak. No, just a minute. Mr. Riram, huh? Accepted notice on behalf of this respondent number
4 and 5.
4 and 5, and Mr. No, Tarak will come first. Yeah, Tarak. Planning Council for accepted notice on behalf of respondent number 3,
6,
3, 6,
8 and 9.
8 and 9, and Mr. Riram for respondent number 4 and 5 has accepted notice on the accepted notice. No formal notice need be issued to the said respondents. Stop. The petitioner shall take steps upon the respondent, rest of the respondent by a registered post with AD within 3 days from today. Stop. List this matter after 3 days. Stop. Having regards to the contention and the submission made by the Planning Council for the parties. Till the returnable date, the parties shall maintain the status quo
My lord,
with regard.
Era 32, my lord, may see.
Yes.
I am repeatedly submitting this. The action of respondent authority in garb of implementing the road.
Para
project-
32.
Yes.
Uh,
Text
page-
27. He is saying that illegally taking away his land. By implementing the road, if his road is affected, then different case.
Hello,
Even
if-
there is
if
no
there is
document to
article
show.
of
it.
construction.
Here, we know.
This is a
Where-
developmental
where-
activities, my lord.
You may be correct. His land may not affect also.
May not affect.
But then you say, and in the present circumstances, because the court has stated, the court has directed, and that has having not been followed, because of
Now,
that.
in that case, let me take instruction, whether they have passed order regarding this withdrawal or not.
Withdraw.
Let it fix on Tuesday.
Okay, just a minute.
If the,
The thing
since it's
that-
a development activity, now working season is on the verge of completion, it will affect hamper.
No, the Planning Council, Mr. Tara. The authority has also to follow certain direction if the court has given some direction to follow the rules. Court has not given any
Why not?
other
I
direction,
accept
extra
that.
direction.
But in the meantime, those person approach the court. When
No.
they withdraw the grievances,
What I'm
what
saying,
remains
what I'm
there?
saying is even the person has approached also.
Huh.
Since the court has.
And
already
when they
directed-
file a, my
directed to dispose
repeated
of
submission, when
by
they have already
speaking
filed
order.
FIR.
By speaking
Let's
order.
have investigation.
By speaking order, passing speaking order. Could have done that at least.
But I have no instruction for that. Let me take instruction by Tuesday. Monday,
Tuesday?
Tuesday. Yes. Then I pass.
Okay, at this stage, Mr. Tarak want to obtain instruction. With instruction
2-3% cannot take the development into right.
Instruction regarding what?
Regarding whether any order was passed regarding this withdrawal.
Instruction regarding, that's instruction as to whether the
The speaking order.
respondent authority has passed any speaking order in compliance with the direction of the court or not.
Now, this withdrawal they have submitted, whether they have any,
No,
No,
even if they submitted, they have submitted also. If the person came and submitted also, then you have to pass one.
my
formal
understanding
speaking
may be
order.
different, while once the person withdraw his grievances,
No,
nothing remains.
But the court has directed to pass a speaking order. Then he has filed, he has withdrawn, then he may again
If
file.
his grievances
file FIR
survive,
also.
then
But
in
but
that
taking
case.
consideration into all this into account, you have to pass one speaking order saying that after filing representation, they have withdrawn and thereafter again they have filed FIR, etc. When considering
Right.
this is the order,
my
then
prayer
they
is that-
could have proceeded.
My friend, let me take instance, whether after submission of this letter,
Yes.
whether they have passed any order. If they have passed any order, that means they have withdrawn.
That is why I'm saying
Huh.
speaking order
So let
in
me
compliance, because after passing,
take
not
you
only
this
after passing,
instruction.
will say that in compliance with the direction of the court.
Before passing of the any speaking order, they have submitted representation, withdrawing their grievances.
Hmm.
Nothing remains.
Be there as it may, my lord.
List is matter on when you say
Tuesday is
Tuesday, next
12,
Tuesday.
12.
In next Tuesday, huh? Till then, the status quo over the
my lord,
NIT dated 5/7/2024.
my lord, this is very developmental activities.
no, that
Supreme Court have clearly stated in various cases.
one SC.
One
cannot-
SC is not above
SC
the code,
cannot
my lord.
violate he is not above the chief or above the courts.
Even above this,
Hmm.
his superior officer, he has bypassed everyone, my lord. What interest he has, my lord, that has to
Only
be
after
looked into.
that
my-
withdrawal, they have passed an order.
Possibly he has a lucrative interest over this, my
No,
lord.
that's
Therefore,
a wrong submission.
so therefore, he does not consider the direction that is passed by the chief engineer. He doesn't consider the direction of this honorable court. And my lord will also direct the authorities to place
Where
it
do
before
we
the
find,
court,
where
my
do
lord,
we find that they are planning to open the financial bid?
tomorrow, my lord.
In
No,
respect,
where do we find that?
My lord,
There's
that
no
they have
report
not,
also.
they have not notified, my lord.
Not proceed.
Just now, my friend has submitted before this court that in respect of one, yesterday they have done it, and
not
tomorrow
yesterday,
they
on
are
7,
Ah.
5th.
fifth.
There
Anyway,
is litigation, so I have come
And-
to know.
tomorrow they are doing it, my lord.
Not proceed.
There's no dispute to that.
Shall not proceed with in person to the, what is this called?
The village
procurement-
vibrant program.
No, procurement press notice or what? What is this? Is this a impugn order earlier?
Well, earlier unit order is 1510.
My
And-
objection may be reported, my lord.
Just a minute. Which one is to be stayed?
No, my lord may say status quo in respect of the NIT dated 5/7/2024.
Where is, okay. The status quo in respect of the NIT, we should, NIT,
Dated 5/7/2024.
5/7/2024. Till the returnable date, huh? Till then, we are fixing on Tuesday, Wednesday, Tuesday, till then, huh? Okay.
My objection may be recorded, otherwise.
No,
the-
on your prayer or we are, prayer,
My
we are
regarding
fixing on
this
Tuesday,
status quo.
status quo.
I am objecting is that there should be no status quo.
Hmm.
Since this is, the grievance of the petitioner is regarding his land is affected. Even if he have no any issue regarding tender process. He is not part of the tender also. So
No,
tender
that-
cannot
that
be
is
stayed.
why you pass a simple once speaking order. That would have been, of course. First
Well,
of the-
they are not passing the speaking order only for one reason, my lord. They will have to disclose that they have followed the guidelines.
No,
They
no,
cannot do it, my lord.
my submission,
In
I
fact-
have no instruction whether speaking order
Can
is
it
passed
be
or
on
not.
18th,
That
my
is-
lord? Can it be on 18th, my lord?
Well,
Instead of 12th, my lord, can it be on 18th, my lord? 18th, I'm coming for something.
We'll say 18 then.
no, then
Yeah.
status quo
It
should
of-
not be there in that case. Subject to outcome then.
No, my lord, subject.
He
If
is
they
not
proceed
part
with
of the
the
tender
construction,
process,
then
my lord.
So if they proceed with the
My
construction,
lord, he is not a part of tender process.
If they proceed with
He is concerned about
then-
land only. He is about land only. If his land is affected, then different case.
Basic minimum.
There is no document to show that
procedure
land
you
is
have to
also belong
follow,
to you.
The direction you have to, the authority in the state or the engineer, whosoever may be, if there is any direction on the, after hearing the parties, you have to follow. That having not been followed, this is only minimum. Okay.
My lord, in the other case, my lord will issue notice, my lord, contempt. The item 23, 24, my lord. There is a contempt, my lord.
But why you are calling? Contempt?
My lord,
Just a minute. Why you have court? Pressing the court?
I'm sorry, my lord. Connected, my lord, because the order.
This is item,
Item 20, 24, connected,
is connected only.
connected.
Notice not yet issued.
Notice not issued.
Don't call before finish, huh? Don't pressurize the court. Please.
Here, my lord, we are alleging that pursuant to the order of this honorable court, the authorities were directed to dispose the representation within 3 months, within 15 days from the date of receipt. And the representation was submitted on 29/07.
Just a minute. Where is the
My lord, the
order?
order, the same order, my lord, which your lordship read in the writ petition page.
Okay. Path, Mr. Kaushik. B. Kaushik, Land Counsel for the petitioner. Stop para. This is an application under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Court Act 1971 for violation of the order dated 18/7/2024 passed by this court in WPC number 272/2024. Start. Issue notice. Returnable by, this will be returnable by
4 weeks. or
4
3
weeks. Para. The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. List is met after 4 weeks.
The other one, my lord, is fixing on 18th. my lord.
No, this we are saying 4
No,
weeks.
this, my lord, will issue notice 4 weeks. Other one, the writ petition for 18th. my lord.
It's 18 only.
Grateful, my lord. Highly obliged.